minutes yet before.
Welcome to the Appellate Division First Department. We have almost 6 hours of argument time requested, so we request that you only ask for the time you need. We have received your briefs and records and are familiar with the case. And before we begin, I would also like to welcome back Justice Gesmer. This is her first sitting back on the bench after her unfortunate leave, so welcome back.
Thank you.
Okay. The first case on the calendar today is People versus Ramirez. Okay, that is submitted. Martinez versus St. Dill for the petitioner. For the respondent? Okay, I'm sorry, did you say 5? Okay. 6 and 1 for petitioner, 5 for respondent. Vogel versus Vogel for the petitioner. Respondent? Okay, I understand there was some confusion, but I'm going to give each side 5 minutes on that case. Sultan versus Connery for the petitioner. Anybody here on, I'm sorry, are you here for Sultan? 6 minutes. Respondent? The respondent is not here. Do you still wish to argue? Yes. Okay, I'll give you 3 minutes. IMP Plumbing versus Munzer, petitioner. Respondent? 5 minutes. Okay, 5, 2, and 5. People versus Schutscha is submitted. Graves versus Brookdale University for the petitioner. I'm sorry, what?
For appellant, petitioner Leonard Hines.
Right, but how much time are you requesting?
How much time you want, sir?
For the respondent? Okay, I'm going to give you 5 and 1 to rebuttal and 5 for respondent. Magliocco versus MKB Family, petitioner.
5 minutes and 2 minutes for rebuttal.
Respondent? Okay, 5, 2, and 6. People versus Lara, appellant. Respondent? Okay, 6, 2, and 6. 19 Stanton versus 19 Stanton, appellant. Respondent? Okay, 6, 2, and 5. People versus Hill, appellant. Respondent? Okay, I'll give you 7 and 1, and respondent will have 7. Russell versus New York University.
For appellant, 5 minutes.
I'm sorry, what'd you say? I'm sorry, I didn't hear you.
5 minutes and 1 minute for rebuttal.
Okay, for respondent?
For respondent, NYU, Squillaci, and Schwartzbach, 5 minutes. For respondent, Comex and Melford, 5 minutes.
Are you with him? Yes. Okay. I'll give you 5 and 1 and 5 and 5. Winkler versus Halmar International.
For the Halmar appellants, 5 and 2, please. For the
Okay, 5 and 2, 3 and 2, 6, 2, and 1. People versus Cromer? Respond? Okay, 7, 2, and 7. Lewis versus Consolidated is submitted. City National versus Baby Blue is submitted. And Cal LaRock Joint versus Patterson is also submitted. So the first case will be Martinez versus St. Dill. Give me one moment. Okay.
Good afternoon. May it please the court. Sim Shapiro from the law firm of Baxter Smith and Shapiro on behalf of the appellants. What we have here is what's really very similar to many, many cases that have been before this court before, where you have a general contractor with a standard, very common clause in an indemnity agreement, which is an arising out of clause. And they and the owner would be entitled to indemnity for any incidents arising out of the work of the subcontractor that they hired. In this respect, it's really no different, and the responsibilities at the work site were really no different. And there's, of course, quite a few cases before this court and all the courts in this state where general supervisory
Isn't the issue
authority...
about your own negligence and whether or not there's negligence on the part of your clients?
There is not. There is not. And the reason there is not, because what you have here is a general contractor with really just general supervisory authorities. There's no indication. This is a means and methods case. This is a case arising out of an incident in which...
But isn't this the case where the general contractor actually had the authority to supervise the work and to provide equipment? And wouldn't that be enough under the law?
It would not be.
To raise issues of factors to negligence?
It would not be. First of all, just as an aside, even if that were the case, that certainly wouldn't apply to the owner. So they even if that were the correct, they'd be entitled.
Before you go on with response, did you break out the arguments in your brief as to the owner and the general contractor, or did you put them together in your brief?
I mean, they're together, but it's that argument as well. It includes the owner.
But did you really make the separate arguments as to each party in your briefs?
It's in our brief as to both, Your Honor. And it's in the court below as to both. But I would add, of course, the court can always search the record in any case and find in favor of the owner.
Okay, why don't you go ahead then and respond to my initial question.
Above and beyond that, simply having that general supervisory authority is not sufficient. In fact, if it were the case, that would really turn any of these cases where general contractors are seeking indemnity on their heads. It would really be very rare that a general contractor could obtain indemnity. This is a case where the plaintiff was abundantly clear that the only parties that supervised him were his coworker and his supervisor at his employer, which of course his employer Ramirez was retained directly by this subcontractor, E.M. Windsor. Just to give you one brief quote from the plaintiff, it's on page 318 of the record. Did you receive any instructions from any of these other contractors that were on the site? No. Did any of these other contractors that were on the site direct any portion of your work? No. Did any of these three contractors or companies that you mentioned to me before, did they ever supervise your work? No. But, Your Honor, I would just add to your, if I may.
Isn't that testimony countered by the testimony of the project director, the Windsor project director, Marique, who said that Liberty supervised everyone on the site and conducted safety meetings? It also had the authority to stop work. It had responsibility for oversight of actual method of work and code and regulatory compliance. Doesn't that counter what you're saying?
It does not. Because simply having the general
Counsel,
supervisory authority, as this court has held,
don't we have an issue of fact here?
that would not be enough to create an issue of fact when they're not actually directing the plaintiff in his work, when they're not exercising that general authority. Again, if that were the case, it would be very rare for any general contractor to be able to obtain contractual indemnity from from a subcontractor. And in fact, just to give one case, not too long ago from this court, Villanueva versus 114 Fifth Avenue Associates, and Your Honor, Justice Gessmer, I believe you were on that panel, that was exactly what happened with structure tone. And this court had held then that, that structure tone, simply by running safety meetings and by walking the job site daily and having the ability to stop work, this court held in 2018 that that was not sufficient.
But counsel, here the owner also, I don't know how you say the name, STDIL. I was calling it St. Dill, but I'm sure that's not it. Had the authority to stop work and the right to access and inspect work at all times. How do you decide this on paper? How do you decide whether the parties, the owner, the general contractor, and the subcontractor were negligent independently? And if they were negligent, how do you decide the proportion of negligence that inures to them? How do you do that on paper?
So I have two parts to your answer, maybe even three, which is one, the testimony itself, there's no testimony from the plaintiff that even knew who they were, or for that matter, ever exercised authority over them. Above and beyond that, this court can and often does awards partial indemnity subject to any finding of negligence. Even then, based on the contract, they'd be entitled to partial indemnity because it says to the fullest extent permitted by law. But lastly, I do want to point out, and I do realize my time is running short here, which is in the court below, my client, on behalf of my clients, we move for summary judgment seeking dismissal of the labor law section 200 and common law negligence claims. Now, it's my colleague's argument that in fact, okay, well, the plaintiff discontinued the claim, so that wasn't a decision on the merits. But that's actually not the case, because they had a cross-claim and a counterclaim against my clients respectively, and could have, in fact, argued in opposition to that motion in the court below, but did not. So this is actually a decision on the merits, and in fact, they waived it in the court below. And by the way, on the same issue, in terms of...
I'm going to let you finish
Sure.
that up on your rebuttal time. Thank you.
May it please the court, Christy Kenzig on behalf of the respondent Ian Windsor. Your Honors, the lower court's judgment should be affirmed because the appellants have failed to prove themselves free of negligence, which they must do in order to show that the indemnity provision is not void as against public policy. The record establishes that they had more than general supervision over the worksite, that they were first contractually obligated to supervise and stop safety violations, and that they did, in fact, stop safety violations when they occurred. They removed at least one employee, terminated another employee. One of the employees was plaintiff's coworkers for
What about
wrongdoing.
the distinction to be made between the owner and the general contractor in terms of the supervision and control of the work? What role did the owner play?
So the record doesn't show that the owner was supervising. They may have had more of a general supervisory role in the construction. However, they're not entitled to indemnification until we determine Liberty's negligence, if any, in this matter, which...
Why is that?
To the extent that the indemnification provision is enforceable, we have to show that Liberty is not negligent. Otherwise, they can't be indemnified.
Go ahead.
Oh, sorry. So Liberty removed and terminated employees, which is more than general supervision. They were contractually required to provide all of the necessary equipment, which plaintiff testified he didn't have. Their own witness said that their role on the site was supervisory, and that they were also responsible for overseeing the means and methods of all of the work that was employed at the work site. We don't have anything in the record to show that the ladder and scaffolding used by the plaintiff was not provided by Liberty. We also have in the record that they provided safety meetings for all of the workers on the work site. They enforced their protocols. So there are several questions of fact that would prohibit finding contractual indemnification here at this point. And then briefly, while it wasn't addressed during argument yet, as far as the claim for breach of contract as an insurance, there are issues of fact. The testimony in whole shows that the Witness did not understand the question and did not know what they were asking. So there's no proof here that they had insurance or did not have insurance, so they failed to sustain their burden there. If there are no questions, I will rely on my brief.
Thank you very much.
Thank you.
Just to finish up on the point I was making briefly before, which is in the court below, the respondent never argued in opposition to our motion on Labor Law Section 200 and common law negligence that, in fact, either of my clients were negligent in any way or had violated Labor Law Section 200. So to say now, oh, that was a decision that was not on the merits because the plaintiff discontinued, they had cross claims, they had a counterclaim, that was their opportunity to oppose it. If you read their papers in the court below, the argument was never made. I do want to just finish up by just reading a quote again. This is from this court's ruling in Villanueva, where it was referring to Structure Tone as a general contractor there. Quote, Structure Tone's project superintendent testified that he was responsible for basic job safety, walked the job site daily, conducted weekly safety meetings with the subcontractors, and had the ability to stop work if he observed an unsafe condition. And then this court, finding that that was insufficient, quoting Capabianca, held where their injury was caused by the manner and means of the work, including the equipment used, the owner or general contractor is liable if it actually exercised supervisory control over the injury-producing work. There is no evidence here that they actually exercised such supervision and control over the injury-producing work. The plaintiff absolutely did not testify that. I just read you briefly before. He testified repeatedly to the contrary. And above and beyond that, I'll also point out that this court has also held repeatedly that even when, which is not the case here, but even when the owner or general contractor were negligent, they would still be entitled to contractual indemnity to the extent that the contract did not impose indemnity for their own acts of negligence. So contrary to what my colleague said about it being void as against public policy, here the language of the agreement specifically says to the fullest extent permitted by law. So at the very least, they'd be entitled to partial indemnity.
Thank you very much. Just going to take a momentary break. It doesn't seem to be working. You press red, you're supposed to be able to reset it. You're supposed to press the red. And then Vogel versus Vogel. The clock is not working right now, so I'm going to keep track.
Fair enough.
So, but I'll let you know when your time's up, okay? Go ahead.
Thank you. Good afternoon. Craig Saunders, if it please the court, attorney for Appellant Ruth Vogel. So what we have here is an ongoing litigation between siblings since 2008. And in that time, plaintiff commenced an equitable action seeking to undo a deed to a condo unit. Now, several years later, in 2014, there was an agreement in Israel that was reached where the plaintiff was going to sign over a deed to my client in exchange for...
Counsel, we're familiar with the facts of the case. Why should any interest be awarded in this case when the other side did not have any control over the money or the benefit of the money while the case was pending, since it was being held in escrow?
That's my argument, that there should be no interest. That
Oh, I'm sorry, I got the sides mixed up. My apologies. I think I got
I like that
flustered by the
question a lot.
time. Okay.
What I was saying, Your Honor, is that exactly that's my point, is that once the $200,000 was eventually paid pursuant to the contempt order, the money was out of my client's control. She bargained for a deed and to pay $200,000. At that point, a receiver was appointed. The money was promptly paid to the receiver. The receiver was not an agent of my client and had no control or custody of the money, nor had any direction as to how the $200,000 was going to be divided up. Frankly, she didn't care. She was obligated to pay $200,000. She paid the $200,000, and I don't see why interest should be charged against her. That's our argument.
Okay, thank you very much.
Thank you.
I think so.
Good afternoon, Your Honors. I'm Daron Zanati, the attorney for the respondent and appellant Winston Vogel. The reason statutory interest should accrue is because on March of 2016, when it was finally determined how much money for contempt damages for Ms. Vogel, and there was a $91,000 balance left, at that point, it was within her control, Ms. Vogel's control, to get the money delivered to Mr. Vogel because she had already received a condo. This is not any different than a closing when you have a balance of the proceeds in an escrow account, and when you finish all the adjustments, and everybody knows you get this, you get that, and then at that point, the buyer has to sign a piece of paper to the escrow agent saying, okay, deliver the money to the seller. Had Ms. Vogel not breached the agreement regarding paying the receiver's commissions and paying those other miscellaneous expenses that were clearly her obligation, this court already ruled in the prior appeal that she had to pay the first $15,000 of the receiver's commissions. And those commissions were quantified at $11,786. There was an additional $6,000 of expenses that were her obligation under a separate paragraph. Her refusal since March of 2016 to pay those fees to this day is the reason that the receiver had to get court approval for an accounting to pay from somewhere, and the somewhere was Mr. Vogel's money. But that's wrong. That's a breach of contract. And from all of the research and cases that I handled over the years, statutory interest on breach of contract accrues from date of the breach.
Sir, what's the nature of this action?
The nature of the action is partition, but pursuant to a court order, as my adversary mentioned, in 2014, Judge James enforced this mediation agreement from Israel as the final resolution of all the issues in the case. So as far as I understand, settlement agreements, irrelevant of the substance of the underlying action, declaratory judgment, preliminary injunction, divorce case, personal injuries, once the parties signed a contract, resolving their issues and deciding how they're going to proceed in the case, the underlying case basically goes out the window, and the only thing that's left for the parties is the contractual issues. Ms. Vogel knows that because that's how she got contempt against Mr. Vogel. Not because there was anything he did wrong in the partition case, but because he didn't comply, according to her, with the mediation agreement. Overlooked in all this is that Ms. Vogel also didn't comply because she had two orders to sign the deed to undo the fraud, the forgery of Mr. Vogel's signature. And that's why there's a receiver, because both parties essentially were, I guess, guilty or did something wrong. Unfortunately, Mr. Vogel's prior attorneys did not take any action against Ms. Vogel, so it looks like he's the bad guy. But in reality, they're both responsible. And it doesn't really matter, because under the contract, Ms. Vogel was responsible to pay these expenses, and she never made any motion practice to revise or modify it. So why are we still here? Why won't she pay those two expenses, those two charges? And the court, obviously, it's up to you to decide whether or not I'm correct in my interpretation that because she should have paid those charges over 5 years ago, that's when you accrue statutory interest. There's no contrary narrative on Ms. Vogel's side as to what else should have been done. She's just saying, I didn't have to pay it. But that's wrong. She did have to pay it, and she still does. And if that's the case, why are we still fighting? And I'm personally, this is the only sanctions motions I ever did in my entire career. But I cannot believe that all she had to do was sign the stipulation, preserving all her rights.
Why was she required to sign the stipulation? Now, what obligated her to sign the stipulation?
Because we're treating this, and again, it's up to the panel, but as basically a closing, where if you're sitting at the closing, and the only way the escrow agent will release the money.
The receiver is controlling the money, not an escrow agent.
No, this, I apologize, Your Honor. This issue regarding the stipulation relates to the money with the New York State Department of Finance. She had no claim on that money.
But why did you need her stipulation to get the money?
Because you need a court order.
Right, but why did she need to cooperate with getting the court order? Why couldn't you just apply?
Oh, I could, but why should Mr. Vogel incur that expense?
But since it required a court order anyway, her signing the stipulation wouldn't obviate the need to go to court.
Yeah, but then
So there was no essential reason, there was nothing compelling her to sign the stipulation. Maybe it would have been the professional thing to do, but it was not compelled.
Yeah.
You still had to go to court, right?
Yeah, but then I just submit a letter requesting a signing, and that's the end of it. I wouldn't have to make a motion and reply to the motion because she's still objecting to it.
Okay, thank you very much.
Yes, thank you, Your Honor.
Thank you. Sultan versus Connery?
May it please the court, my name is Burton Sultan, plaintiff appellant pro se, and I thank you for hearing me. My uninsured loss is $230,000. The stipend of settlement is a mistake, $10,000.
But you signed the agreement. You agreed.
I did not sign it.
I'm sorry,
no,
you didn't sign it,
no.
but you were allocated
I was
by the,
allocated,
excuse
yes.
me, you were allocated by the judge. You were sworn in. You said that the settlement was satisfactory to you. Am I correct?
I didn't have the capacity to do that because I had a subdural hematoma. I was, on the 5th of August, I'd had an accident.
Mr. Sultan, I
Yes.
understand that you said that, but in terms of the papers that you gave us, the only document that was in the papers concerning that was in September. So we can't infer from the medical records in September that you were unwell in August. So what could we base a finding about that on?
Well, a subdural hematoma is a slowly, it's blood in the brain, on the surface of the brain that slowly imposes itself. We didn't know when it was, at that time, the whole story had to be told. In the 5 weeks, I had to undergo emergency surgery on a Sunday. And that was
the operative
the
report.
consequence of
Mr.
the-
Sultan.
You have to stop when a judge asks you a question. You have to stop and let the judge ask.
Yes,
Yes, the operative report that you submitted to the court is dated September 15th.
yes.
So it makes no reference to events that happened before that date. We don't have any documentation to corroborate what you are saying to us. That is a problem.
The operative report did say that the accident occurred on August 5th.
Sir, I have the operative report here in front of me. It doesn't mention any dates other than the date of the operative report and your date of birth. So the date of the visit, September 15th, 2019, and your
That's
date
the
of birth.
operation, yes.
Yes, and your date of birth. So in order to undo a settlement, which is so ordered by the court, where you've been allocated, where you've been represented by counsel, you would really have a high burden to overcome in order to show fraud or collusion or mistake or an accident. Any of those things. It can't just be that you say them to us.
The history of the trauma was on the 5th, and that is recorded in the medical record. It's exactly in the medical record at that time. So it is there.
Thank you very much. Thank you.
That's it?
That's it.
Okay.
IMP Plumbing versus Munzer, I'm sorry.
hopefully Anna writes that.
May it please the court, my name is George Sava, Porton Sava, for the appellant in this matter. What's before the court today is pretty much a watershed case, because if the lower court's decision is upheld, two things are going to result. One is the integrity of the profession, in that no matter what an attorney does, no matter how many mistakes, no matter what processes they take to remedy it or failures they do after the fact, they will get paid for it all, and their legal fees will be paid by the client. Proof of this is that the defendant in this case was pretty much emboldened, because after it was issued, he brought counterclaims seeking additional fees for $130,000. The second thing that will happen, excuse me?
Is that in the record?
It's not, because it occurred after.
If it's not in the record, we can't consider it,
I understand
counsel.
that,
I
Your
just
Honor.
wanted to remind you that you shouldn't rely on it because we can't consider it.
And I'm not asking.
Isn't the issue whether or not there was or was not malpractice? So either there is a viable claim on malpractice that can go forward, or there's not a viable claim. I'm not really sure what this grand point is that you're making.
Well, I mean, it's
Either
twofold,
they
because
did
there's,
something wrong and they can't recover their fees, or they didn't do something wrong and they can recover their fees.
well, there's malpractice and there's breach of contract, Your Honor. And so fees.
But what's the grand, I don't understand what the grand argument is you're making.
The grand
Why wouldn't you look at each individual action and decide what was done in each individual action? And why, then don't you explain to us in each action what you think was the malpractice or breach of contract that you think you're entitled to recover for?
Absolutely, and I will direct the court to the matter of Cochia versus Lusati, which we do reference in our papers, because this was a second department case that dealt with facts very similar. But in this action, Your Honor, I will tell you that you had 4 actions that we referenced. 2 of the actions, default orders were rendered for failure to do something by the counsel. The second 2 actions were dismissed entirely because they weren't properly.
What are you seeking to recover in the first 2 actions? What is it that you're seeking to recover in this lawsuit?
The damages, and we cite the cases, and I also cite this case as well, the damages are the additional cost incurred just to get the cases back to the starting point.
Okay, so your argument with respect to the first 2 cases that you should recover the additional legal fees that were incurred to get the case back on track.
Exactly, Your Honor. And we cite cases that
Okay, so
that
let's
is
go on
proper.
then to the other 2 cases, what the alleged malpractice was.
The alleged malpractice is, and as you will see from the court orders, it was failure to properly plead the causes of action made. It was also one where the notice of pendency was improper. So,
Did you explain how pleading those proper causes of action would have ended up with a different result in that litigation? What the merits of those unpled things were that would have changed anything in terms of the ultimate disposition of the cases?
absolutely, because you were talking about, in those particular cases, properties that the allegations were that they were wrongfully taken, monies were wrongfully taken, and the rest. By failing to properly plead the causes of action, by getting them dismissed simply because you didn't take the effort to actually put down the elements within the claims, yes, we have to then obviously prove the case. But it does raise the issue of whether that was malpractice by getting them dismissed, not by even following procedure.
Because it's malpractice, don't you have to show why there would have then been merit to those claims if they were then asserted? And have you done that in this proceeding?
Well, we feel that we have, because by way of the affidavit that we put into the court, it raised numerous questions of facts. I mean, the court took a 3211 pre-answer motion, switched it into a 3212, and then ignored the affidavit of the plaintiff itself, which raised numerous issues with regard to each individual claim, the monies that were paid, the $250,000 that was paid, the $200,000 that was put for purchase of property that they never saw again. All these things were raised, which at the very least creates a question of fact, which would allow the claims to move forward, similar to Cochia versus Leotti.
The court let you move forward on the $200,000 claim.
They did. They did. That one is the conversion.
And that claim is still in existence.
That's still in existence, but Your Honor, but what we're dealing with here is, because the second aspect of this, and it's very important, is that the underlying case essentially allows a disbarred attorney to work for a law firm and provide legal advice to a client. And under the rules and under case law, that in itself is a forfeiture of fees.
It doesn't allow that. It just means that they may not be liable for damages for having done it. That's a very different thing.
Well, no, the damages...
Whether or not it's a proper thing for a law firm to do is one question. The second question is whether somebody else gets damages because of it, and they're quite different.
Well, that's why...
Analytically, because the problem is that you didn't show that your client was damaged by virtue of the disbarred attorney having worked on the case.
Your Honor,
I'll let you quickly respond to that, and then,
I again cite the case of Cochio versus Lusati. The Second Department laid this out specifically how it is, how the aiding and abetting a non-lawyer in the practice of law results in forfeiture of fees.
okay, thank you very much.
Good afternoon again. Craig Saunders, Munzer and Saunders for defendant respondents. Everything that you just heard from counsel, Your Honor, was simply allegations. And
Let me go back to the first two actions, which were the concrete actions. Why shouldn't, under the circumstances of this case, the client be able to recover legal fees incurred in connection with vacating the default, vacating the contempt, since it's undisputed that certain actions were not taken by the law firm and allowed the default to be entered?
Are we talking about the default in the action out in Long Island? Because if that's what we're talking about, that was subsequently reversed.
Right, but weren't legal fees incurred in having
I don't know. It was never pled. I don't know what the legal fees were. I have no idea what was done by plaintiff's
Why
counsel.
shouldn't they be entitled to prove what, I mean, because this is a summary, why shouldn't they be able to prove what legal fees were incurred with respect to the vacating of the default and the appeal, which then arguably would be allowed to recover?
There was no appeal of that.
Well, they hired new counsel to appeal.
Well, just because he hired new counsel, you'd still have to show, not only show, and this is the key thing here, because it was originally a 3211 motion that was converted to summary judgment. Plaintiff has to put his proof forward, not just make allegations.
Well,
They
there's
have
no
not alleged-
dispute that there was a default. Is that correct? There's no dispute that they didn't request leave to file an answer and that a default occurred.
What had
And
happened,
that work had to be done as a result of that default.
whether work had to be done or not, I don't know, because by the time that I had left the case was opened up. What happened was there were settlement negotiations going on. So we did not put an answer in at that time. And ultimately, after making motions to the court out in Suffolk County, they agreed with my position that, in fact, settlement negotiations were going on, the default was vacated, and we had even put in an answer before new counsel had taken over. So there was no need for whatever funds were expended, if there were, by plaintiff, because the matter was rectified. As to the other matters, there was no proof. This is a 3212 motion. They didn't hire an expert. They have to show an attorney-client relationship. No question about that. They have to show negligence. They haven't proved that. They have to show proximate cause.
Well, hold on. In the Suffolk County action and special proceeding, there were two, both brought by the same plaintiff/petitioner, AM
Concrete.
Concrete, okay. No answer was interposed in either one of those action/proceedings, correct? And no pre-answer motion was made.
That is correct.
So the
Well,
plaintiff
ultimately-
here,
I'm sorry, ultimately there
client, is
was
now
an
put in a
answer.
default posture.
Well, the default, there was a question as to whether or not there was a default in one of them, which was ultimately rectified by showing that there were settlement negotiations which vacated the default, and an answer was put in. My firm did put in an answer. It was then taken over by present counsel. As for the other one, it was seeking an accounting of funds, and we had turned that over to counsel back in February of that year, and there was an order of contempt that came through back in October, and that's really on new counsel. I don't know why new counsel didn't respond to that.
Counsel, I have a different question.
Sure.
What say you with respect to the consequences for employing a disbarred lawyer to allegedly work on the plaintiff's cases?
Well, again, allegedly. There was no proof. They're claiming that Mr. Bernstein, who I know because I share the same office, somehow represented the plaintiffs. Well, they don't say where, how, when. There's nothing in the record. There's no evidence. He drafted papers. He went to court. He argued. He did anything. In fact, it was through Mr. Bernstein is how I got the plaintiff. So if plaintiff really thought Mr. Bernstein was an attorney, there'd be no need for me to appear on his behalf. This whole thing is all allegations and speculation. There was not one single shred of proof submitted on the 3212 motion by the plaintiffs. There's nothing.
Thank you very much.
Thank you.
I will just quickly sum up. With regard to the docket and everything that occurred in the number of motions, it's in the record, the docket on both of those initial AM cases. The lien law case, the second case, the emails are also in there saying, ignore it, ignore it, ignore it, which led to the contempt motion. By that time, we then had to fight that. By that time, my firm was brought in. As to Mr. Bernstein, I would direct the court to page 284 on the record, which is an email from Mr. Saunders that says, Mark and I will be there to prepare him for a deposition. So I don't think that's a pie-in-the-sky allegation. I think that's a direct statement by counsel that he is bringing a disbarred lawyer to help the client prepare for a deposition, which I define as legal advice. Thank you. Unless there's any questions.
Graves versus Brookdale University.
May it please the court, Lennox Hines representing appellant petitioner. The central issue in this case is whether or not the relation back doctrine should apply to Dr. Chandri. We believe that Moran versus Copal is instructive with respect to how we should approach
Mr. Hines,
this question.
could you address the third element of that test, which is whether or not the defendant should have known that the action would have been brought against him, but for a mistake by the plaintiff as to the identity of the proper parties? How could the doctor have known that the plaintiff intended to bring this proceeding against him, especially because he was not deposed until some years after the running of the statute of limitations?
We believe that Brown versus Midtown Medical Center, in fact, sets out why Dr. Chandri was on notice. And why do we say this? We say this because this court held that if there is an employment relationship between the hospital and the doctor, then that the doctor is charged with notice with respect to the malpractice.
But that addresses whether or not he had notice of the institution of the action, that it's a separate element of the test to know whether he should have known that he would have also been named as a defendant. And that's the element of the test that I'm asking you to address. Even if he knew it had been instituted, how should he have known that they intended to add him as a defendant?
The holding in Brown established, and this court ruled, that where there is an employer-employee relationship, that an action being brought against the employer puts the employee on notice. And we are relying upon Brown versus Midtown Medical Center. Also, we look at Alamo versus Citadent Inc., which is a Again, a First Department case in 1910.
What
And this
year,
court
Counsel?
held that
What year, Counsel?
even in the case,
1910?
I beg your pardon?
I'm sorry, did you say it was a 1910 case?
I'm sorry, 2010.
Okay.
The First Department held that even in the case of a former employee, in this case a dentist, that former employee would be charged with notice of a suit against his employer. And in Austin versus Interfaith Medical Center,
I'm sorry, so your position is that every time a hospital is sued, all of its employees should automatically know that they're also involved in the suit? Like the hundreds of employees at the hospital all should know that they're involved in the suit because
no,
they're an
not
employee?
all employees.
So
Employees,
this doctor
as in
wasn't,
this particular
this
case.
doctor wasn't listed in the complaint. There was no Jane Doe, John Doe allegation. How would this, assuming he's an employee, which I think is disputed for purposes of medical treatment, but how would he know that he was going to be sued individually as opposed to the hospital being sued and the hospital being responsible?
Based upon the facts. Not all employees, but in this case, Dr. Chandri.
Which employees then? What's the test that you're articulating as to which employees would know that they're being sued individually?
In this case, we are looking at an employee who in fact treated the patient, and his footprints are all over.
Okay, thank you, thank you. Let's hear from respondent.
Good afternoon. May it please the court. Samantha Quinn for Defendant Chaudhry. First of all, I just want it to be noted that I withdraw my first point in my brief, given the Second Department ruling in Brash versus Richards. This court's decision in Graves versus Brookdale in 2019 is squarely on point and should guide this court in its decision today. It's the exact same facts and circumstances. Judge Capella decided, and this court affirmed, that statute of limitations had run and that the relation back doctrine was inapplicable. Dr. Tavdi was the other named defendant, and he found that it was not shown that the hospital and the doctor were so united in interest that he should be charged with the intent to sue him. And as per your questions, how could this doctor know? These events occurred in 2006. I believe his treatment of this patient was on one day in March of 2006. The dates of the original complaint span 26 days. There were numerous people who treated the patient. How was he supposed to know that, like a decade later, he was going to be named in this suit? And in particular, the distinction between the other Graves matter and this one is that Dr. Chaudhry was actually deposed. He was deposed in 2014. However, this suit wasn't instituted until over 2 years after that deposition. So that cannot be noticed. It can also not be noticed because the linchpin of application of the relation back doctrine is that the defendant had notice within the applicable statute of limitations. Here, his deposition was in 2014. The statute of limitations ran in 2009. There's no way that he can be charged with notice. If the court has no further questions, I will rest on my brief.
Thank you very much. You have 1 minute.
Just a short rejoinder. Brookdale Hospital was served a bill of particulars in which Dr. Chandri of Brookdale requested the names of all employees who could be held liable for the malpractice against plaintiff appellant.
I couldn't find that bill of particulars in the record. Could you tell me where it was?
Yes, that was submitted in terms of the bill of particulars that was served upon Brookdale. Dr. Chandri was named as one of the individuals who is liable.
Thank you. Magliocco?
Good afternoon. May it please the court, my name is Simon Block from the Quinn McCabe firm here today representing plaintiff appellants Joseph and Allison Magliocco. The trial court committed reversible error in dismissing appellant's claim for trespass in its entirety and portions of its claims for private nuisance and breach of contract.
Let me ask you about the trespass and the nuisance first.
Sure.
Why aren't those claims barred by the prior settlement agreement that the parties entered into, at least with claims that pre-existed the settlement agreement?
They are, Your Honor. If you look at the record at page 69, there's two sentences. They don't read like standard release language. The trial court noted that, but in any event, they're very clear that they are compensation for damages to the adjacent premises itself, property
Doesn't
damage.
it say in the language of the settlement that it's to satisfy all past damages without any limiting language, which would limit it just to, any specific thing?
No, Your Honor, it says, and I'm reading from the record at 79, that payment of specific invoices is in full satisfaction of all past damages caused to the adjacent premises by the project. The very next sentence also refers to known damages to the adjacent premises. And that's very important because there's case law cited in our briefs, Ivory from the 3rd Department, that specifically holds that while a plaintiff may release a claim for property damage, that does not affect the release of the claims for both trespass and private nuisance.
Where in the stipulation or the settlement does it state that it's limited to property damages? Where is the language in the settlement agreement containing that limitation?
Your Honor, it's the language I just read to you. In other words, the law is clear that release language is to be construed narrowly. There was able counsel assisting in the negotiation and drafting of this agreement, and they clearly knew how to affect the general release if that was the intention. That wasn't the intention as evidenced by the plain words of the document, meaning it says this is compensation for damage to the property itself. As Your Honors know, claims for trespass and private nuisance are not claims for damages to property. They are, in the case of trespass, injury to the right of possession. And the case law is clear that you can have damages for annoyance, inconvenience, things that have nothing to do with damage to the property itself. These were in paragraph 5 of the settlement agreement, this was compensation for invoices for repairs to damages to the property itself. There is no requirement that there be an exclusion language in the settlement agreement. Rather, there has to be a general release if that was the intent, and based on the plain reading of the document, that's not the case here.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Maurizio Anglani from Ingram Music and Carolyn Bertolotti for the respondent. Your Honors, we respectfully submit that the appellant's interpretation of the agreement is limited to the provision itself, which, as Your Honor rightly pointed out, broadly includes all past damages caused to the respondent's property and all known damages caused to the project owner by the project owner to the property. Even if that language were to be interpreted to be limited to the property itself, the context of the agreement is very important here. This was an agreement for a license, meaning an agreement to allow the respondent to access the appellant's premises. The agreement itself, and in fact, even the appellant's complaint states this, recognizes that there was a history of disputes that goes back years before the access agreement. And then the agreement says, here is how we're gonna deal with the issues that have come up to date. We're gonna enter into an agreement that says, we're allowing you to keep the encroachment, so-called, on our property. We're allowing you to pay us damages, the very same damages that are allegedly arising from the trespasses and nuisance.
Let me ask you about the breach of contract claim, though.
Yes, Your Honor.
Isn't the breach of contract claim based on the argument that there was an agreement that they were supposed to remove anything encroaching on the adjacent premises and that they failed to do that?
Yes, one of the allegations.
Why shouldn't that survive?
For two reasons. One is the court below already reserved the appellant's right to pursue a breach of contract cause of action based on an injunction, which they're seeking to remove that so-called encroachment, which is the old scaffold, and replace it with a new scaffold. The court reserved that claim. Secondly,
I'm sorry, what do you mean the court reserved? I'm not sure I'm
the
following.
court did not dismiss the portion of the breach of contract claim which seeks an injunction to
But
remove.
what about the breach of contract claim that seeks damages?
That's my second point. The court also reserved the nuisance claim arising out of the same allegation which the plaintiffs are alleging caused them to be in fear of their life.
But why shouldn't there also be a breach of contract claim?
Because there are no separate damages. That allegation has one resulting damage, which they're alleging, which is we lost use of our yard because we were in fear of using that yard. Now, the court below said, you have a nuisance claim for that, rightfully so, because that allegation is a tort allegation. Well, those damages, I should
But
say.
why can't it also be based on the contract which said you are going to remove the encroachments and you did not do so?
If there were damages, but otherwise, what are we talking about? We're talking about the same damages, but I don't perceive those damages as contract damages. Those damages are tort damages, loss of use damages arising from being in fear of danger from falling debris, etc.
I guess I'm not following you because it's a contract that says you're going to do something and you don't do it. Why isn't that a contract claim?
No, it is a contract claim, but a contract claim also requires damages, and the damages that are being articulated here are loss of use as a result of being in fear for falling debris, etc. That allegation is the only allegation that has been cited as damages, and that allegation is a tort allegation. It's damages sounding in tort, not in contract.
Well, what a plaintiff said, you know what, I don't like, the elements for nuisance are more difficult to meet than the elements for breach of contract under this circumstance. So I'd like to go forward with my breach of contract claim.
Your Honor, I agree with you. However, we have to rely on what the complaint is alleging. The complaint is alleging specifically that the failure to remove the scaffold caused certain damages. Those damages are specifically loss of use as a result of being in fear of using their backyard, okay? That allegation is based in tort. It's not in contract. The reality is that even if the allegation that the scaffold wasn't removed were true, there are no breach of contract damages that accompany that breach. The only damages that are being articulated are damages arising out of the nuisance, which was reserved. And if there are no further questions, I'll rest on my brief.
Thank you.
Thank you.
Your Honor, very briefly, I'd like to make just two quick points. The first related to my colleague's assertion that you need to look at the context of the agreement, which was also in his brief. That's just not correct under basic statutory contractual interpretation. You read the words of the contract is clear as to what the compensation for property damage was. It was for property damage, and I'll leave it at that. The second point, I just wanted to briefly address the breach of contract claim. As Your Honor correctly noted, the agreement did require them to remove the encroachments. They didn't. It's a simple, straight breach of contract claim. The fact that the trial court allowed appellants to pursue loss of use damages on a nuisance theory doesn't, on this 3211 motion, prior to any discovery in the case, obviate the fact that we can also plead and pursue breach of contract claim. And
Sir, how do you
obviously, we're
respond
allowed
to your
plead in
friend's
the alternative.
argument that the nature of the damages you allege in your complaint are of a tort-type nature and damages as opposed to a breach of contract-type damages?
Yes, Your Honor. So in Sheer Enterprises, which is quoted in our brief, this court said on a 3211 motion under CPLR 3014, you can plead in the alternative. And the fact in that case that plaintiff had a fraud claim that was allegedly duplicative of its breach of contract claim because the plaintiff sought the same damages under either theory wasn't sufficient to dismiss the breach of contract claim.
Counsel, your adversary seems to be arguing that the damages here are de minimis because they just involve fear, nothing more. Fear of falling bricks, fear of debris, and okay, so we'll go to court over that. What do you have to say?
Well, Your Honor, those damages are very real. As pled in the pleading, my clients did not use their backyard, so they lost the ability to use their property for a very lengthy period of time because of this breach and because of the fact that the scaffolding that was encroaching wasn't removed and replaced with safe scaffolding, which was also a requirement of the agreement.
Thank you very much.
Thank you.
People versus Lara.
Good afternoon. May it please the court, Shayna Watrous on behalf of Jesus Lara. The trial court should have instructed the jury on agency, but didn't because of a mistake of law. The law is clear that agency may be raised alongside an inconsistent defense, but the judge denied the instruction because of Mr. Lara's inconsistent defense. The court's denial was clearly—
What about the separate reason for denying an agency defense, which is that it would not be viable under any circumstances? How can there be an appropriate agency defense where it's undisputed that defendant had a relationship with the seller and that he negotiated the price and was involved in a prior drug transaction? Aren't all of those things together enough to say that there's no viable agency defense as a matter of law?
Your Honor, those things are not undisputed.
Not what?
They're not undisputed. Those are not undisputed facts. So first of all—
They're in the record.
They're not all in the record, no. He did have a relationship with the seller, which is not sort of a deciding factor in determining whether an agency defense applies. What really matters is whether he had a relationship with the person who wanted to buy, the actual buyer. So, just the fact that he
It's not enough, though, just to have a relationship with the buyer, though. You have to show much more than that for an agency defense.
Correct. So, but that's really the relationship that matters. And we have here that he knew Torero for a full year beforehand. There was clearly a relationship there, and looking at this in the light most favorable to the defense here, Torero was the one who kept telling Mr. Lara, I want to make a buy, I'm looking to make a buy. Mr. Lara didn't stand to profit from this. There was no evidence of that. He never touted the quality of the drugs. He didn't negotiate the price here. It's very clear that there was some evidence that he was an agent in this case, and the jury should have been able to determine that and determine the weight in that case.
Assuming that you're right and you were entitled to the agency defense instruction, would that affect both charges, just the top count or just the inferior count?
Your Honor, I believe he should get a new trial on both counts, because it wouldn't really make sense to the jury to just be given, given how the agency defense applies, to just be given one without the possession charge, wouldn't allow the jury to understand the nature of that defense. These were inextricably linked charges, so it would make sense to present them both to the jury.
Let me ask you, what defense did he give that would invoke the agency defense other than saying he wasn't involved in the transaction at all?
So Mr. Lara said that he had no knowledge of the transaction and he wasn't involved, and that's.
What proof did he provide that supported the agency defense?
So he didn't have to provide that. It could have just come, as the Court of Appeals has said, it can just come from the people's argument.
You said some of the things were disputed. So what evidence was there that was disputed about the lack of agency defense?
I mean, everything was disputed. I'm sorry, I'm confused by your question. Could you restate it?
Well, he said he wasn't involved in the transaction at all. So what evidence is there to dispute that he was involved in the negotiation of the price?
The people's own evidence. So the people's witnesses, this was elicited by defense counsel when he was speaking to the people's witnesses. Sorante, the person in the prior transaction, said that it was not negotiated by Mr. Lara, that seller told them the price, and that was a negotiation. And in this case, there was no evidence that he set the price here. It was just they went and Mr. Burgos, took out the drugs and said, "This is the price." Told them the price. It was clear that Mr. Lara was not the seller in either case.
To what extent should we give weight or strength to the fact that there was Molyneux evidence that your client had been involved in a previous drug sale, which under the Lamb-Luck factors would be a factor to consider in whether the charge is appropriate?
Well, we also are making the argument that Molyneux evidence should not have been admitted. Is that your question, or should I?
Well, let's assume it was properly admitted, or at least for the purpose of looking at this discrete issue, we can consider it.
I mean, it can be considered, but that's really something that the jury should have been able to consider. This should have been presented to the jury so that this court could now be evaluating the weight of the evidence, but we don't even have that. The jury couldn't even, didn't even know that this defense existed, so couldn't have considered it. So I would just ask that Mr. Lara be granted a new trial, given that there was at least some evidence that he was an agent in this case, and that's looking at this in the light most favorable to him, and also understanding that this decision was heavily clouded by the court's misunderstanding of the way that the law should be applied. That the court said at the end, or said initially, your client has denied any knowledge whatsoever. He had no involvement. So how on earth, based on the testimony in this case, can that be relevant? And then the prosecution argued that the inconsistent defense wouldn't allow the agency defense. And then at the end, after the court ruled that you can't have, that the jury would be confused because they would have to disregard Mr. Lara's testimony, then at the very end, the prosecution says, I agree that a reasonable view of the evidence does not support the defendants having it both ways. So I agree with your Honor's ruling. It's clear this was based on the mistake of law. Thanks.
Good afternoon. May it please the court. My name is Megan McLaughlin on behalf of the people. Now, I'll just begin by addressing counsel's arguments as to the agency defense. There was simply no reasonable view of the evidence that supported the theory that a defendant was acting as an agent of the buyer, the confidential informant. The prosecution's case established that the defendant was attempting to sell a kilogram of heroin to the concert.
Is this the argument, though, that it wasn't defendant who was actually attempting to do the sale, but that it was a third party who was the seller, and that he was just simply assisting the buyer?
Well, Your Honor, first and foremost, as the court has already pointed out today, the defendant was the one reaching out to the confidential informant. So Torero had testified several times and actually clarified when asked by the defense attorney, I never told Lara, the defendant, to look for drugs for me. He would offer them. So it became clear through that testimony that the defendant was reaching out to the confidential informant to try to sell this kilogram. It was not something that Torero was constantly bugging for, and it was not the supplier, Junior Burgos, who was reaching out to Torero. Now, In addition to the prosecution's case establishing that the defendant was trying to sell this kilogram of heroin, the defendant's case also did not provide any evidence to the contrary that he was actually acting as an agent of the buyer.
About defense counsel's argument, though, that testimony was developed through the people's own witnesses.
Yes, Your Honor, the defense attorney did attempt to establish these factors through the witnesses, but many times, as was already discussed, the confidential informant clarified, I never was trying to look for the drugs. The defendant was reaching out to me. He did, in fact, testify, the confidential informant, that the defendant negotiated the price with him. At the very least, he told him how much it would be, $56,000. And the prior incident, as the court has pointed out, also established that defendant had the intent to sell this heroin based on his prior experience in doing so. Now, if Your Honors would like for me to move on to the Molyneux aspect, or if Your Honors had any more questions on the agency, I just want to make sure that I address those points if Your Honors had any questions about either the Molyneux or the excessive sentence points after the agency. If there are no further questions, I rest on the brief. Thank you, Your Honors.
Thank you very much.
Your Honors, it's true that at one point Torero said, I never asked Lara to look for drugs for me, but he also several times said, I would tell him, I'm looking to make a buy. I want to make a buy. Mr. Lara would just say to him, according to Torero, Mr. Lara would say, what's up? And Torero would say, I'm looking to make a buy. So the fact that at one point he said, I never told him to look for drugs for me, doesn't mean that he wasn't telling him, I want to buy drugs, I want to buy drugs. Like, this was suggested by Torero. And we know that Torero had, the incentive to be looking for drugs. He was only paid when he got drugs. So, the jury, certainly there was at least some evidence that the jury could have found that this was initially, this was suggested by Torero. So the court should have allowed the jury to consider that.
Let's assume you're right and you should have got that instruction. Address the harmless error point by the people, please.
Well, it's certainly not harmless because Mr. Lara was convicted of this charge that he could have been acquitted of. If the jury knew that this was a defense, there was a view of the evidence that the jury could have, not found him guilty of this point. And that's incredibly harmful for him. This is an aggravated felony. He's a non-citizen. It really matters that the jury couldn't consider this defense to this important charge. Certainly not harmless. If there are no further questions, thank you.
Thank you very much. 19 Stanton Street versus 19 Stanton Realty.
Your Honors, good afternoon. May it please the court, John Nutter for the appellant, 19 Stanton Street, LLC. Your Honor, the first point here is whether the doctrine of merger applies to extinguish appellant's claim for attorney's fees in this action. And the answer to that question is no. In the prior underlying action, Judge Crane did not hold that the respondent's fraud claim was extinguished upon the closing of title. Rather, the judge held that there were specific disclaimers in the party's purchase.
Putting aside the viability of the fraud claim, how does a merger doctrine not bar this lawsuit where there is clearly no survival language in that provision regarding attorney's fees, and there clearly is survival language in other provisions of the contract?
So, Your Honor, the survival language is one exception to the merger doctrine, where there's a clear understanding as expressed in the contract. That's one exception that does not apply here. The exception to the doctrine of merger that does apply here is for a collateral undertaking.
And how can an attorney's fee provision be collateral where that is one of the main ways of enforcing provisions of the agreement?
In my view, Your Honor, it relates to disputes. It doesn't relate to the conveyance of title, possession, et cetera, those parts of the contract which actually convey the title. It relates to disputes. And in this case,
About the conveying of the title.
or any other dispute, or any other dispute. And this dispute, this claim was a fraud claim. It was a fraud claim wherein the court had to go back and look at the agreement and assess whether or not the disclaimers were specific enough, whether the integration clause was broad enough to bar that fraud claim. The court found that the contract was sufficient to bar the fraud claim. And I believe that this very broad attorney's fees clause is in fact a collateral undertaking because it solely relates to disputes. And these disputes.
Counsel, if you look at section 25, it says that pretty much everything under the agreement dies once the agreement is terminated, unless there are express terms stating otherwise. So if you look at the attorney's fee section, which is in 30.3, and you look at the jury waiver part, which is in 30.1, so they're very close to each other. 30.1 specifically says that the jury waiver that it survives the delivery of the deed, but the attorney's fees part doesn't say that. So how are we supposed to step into the role of the parties who clearly negotiated this lease?
Your Honor, I think you don't have to step into the shoes of the parties. What you have to do is look at the clause at issue, the attorney's fees clause. Did the parties reserve the right expressly for that to survive the closing? No. But under the common law rule, doctrine of merger and its exceptions as to what is a collateral undertaking, I think that's the issue you really have to decide.
You're splitting a cause of action, aren't you?
I'm sorry.
I mean, so you have, usually when you ask for attorney's fees, you do it within the contours of the action that you've earned, where you've earned the attorney's fees. You don't start a separate action.
Well, in New York, in our permissive counterclaim state that we have here, you don't have to make that claim for attorney's fees.
We decide this very issue very clearly in O'Connell, that it is a splitting of a cause of action to assert attorney's fees in a different action, and why is that not binding authority in this case, separate and apart from the whole collateral argument?
Understood, Your Honor. And we recognize that O'Connell did apply the claim splitting rule under these facts, and the trial court held that it was bound by O'Connell. We are expressly asking this panel to reconsider that portion of O'Connell.
And why should we do that?
Because we believe that it completely negates the permissive counterclaim rule. We believe that for the reasons set forth in the Carrickhouse case, the Fourth Department case, applying the claim splitting rule against a defendant who asserted no counterclaim and was not required under New York law to assert any counterclaim is manifestly unfair, and like I said, completely negates that permissive counterclaim rule. If you're not required to assert it and you don't assert it.
It doesn't completely negate the rule. It only finds that it doesn't apply with regard to attorney's fees. That's very different.
I mean, well, it negates it for purposes of an attorney's fees claim, which can be very, very important to parties. And I just don't see, there's certainly no statutory support for, a doctrine that states you have to file a counterclaim for attorney's fees in that action. That's not.
Sorry, didn't we recently rule not to adopt the Fourth Department decision in Barrett, Japaning versus Villa Broda, which was issued this year?
Your Honor,
I think a number of my colleagues were on that panel that had this very issue.
This very issue. Your Honor, I did not cite that in my brief, and neither did my opponent. I would be happy to issue any post-argument submission with respect to that case.
Thank you very much.
Good afternoon. If it please the court, Paul Gruber from Borough Goldstein, Altshuler, Naines, and Gardell, representing 19 Stanton Street Realty. The order of Justice James should be affirmed in its entirety. The merger doctrine is absolutely applicable here. This contract very specifically and clearly spelled out what survived the closing, what did not survive the closing. And as I believe Justice Gonzalez pointed out, the attorney's fees provision did not have that language of survival. This is New York. The rule about a contract is fairly simple. A clear and unambiguous agreement will be enforced as it is written.
What's your response to the argument that it's collateral and therefore it does get to survive separate and apart?
No, it's not collateral because essentially the attorney's fee claim goes to the heart of what the action was. Whether or not my client was entitled to damages for the plaintiff's fraud. It's simple as that, really. It doesn't the collateral doctrine relates to something that's extraneous. This is part and parcel of the contract. It merged. It's no longer surviving, and also. Justice James noted about the splitting of the cause of action doctrine. Now,
But sir, didn't we in Novelty Crystal Corp versus PSA define a collateral undertaking as a contractual commitment that is not connected with the title, possession, or quality of the land?
Well, this court also said that it's not extraneous to the contract or creates a separate obligation. I don't see where they say that there was a separate obligation created as a result of what transpired here. Further, this was a claim that could have been litigated but was not during the course of the initial action. And res judicata and the splitting doctrine in this state are fairly broad about that and in precluding piecemeal litigation, which is what we're having here. One of the things he makes reference to is a Fourth Department case, Calcus, I think it was, and that is quite a different thing than what this court had in O'Donnell, quite different. There you had a residential tenant who had breach of lease issues with their landlord, and the court ultimately ruled on Real Property Law 234, which is a statute that expressly permits the tenant to split its cause of action. There's a similar statute in mortgage foreclosures where with the legislature, which we assume is cognizant about the doctrines of, with respect to counterclaims and splitting a cause of action, was fully familiar with. It certainly didn't address this in the real estate contract context. But where it wanted to have a split, it certainly said where you can have it. This case in O'Donnell, the court's decision in O'Donnell, as far as I can read it, involves somebody not saying the contract was breached, but it was a fraud to begin with, and thus maybe the attorney's fees clause that might have been in that lease that the landlord was seeking to rescind didn't address it. I'm pretty sure that I've argued a lot of landlord-tenant cases in front of this court, as you're all aware. And I'm pretty certain over the years that if this court wanted to make it plain that it was relying on Real Property Law 234, it'd say so. I leave everything else to my brief. I just want to close with one thought. We shouldn't forget what happened here and what brings us to court today. What the seller did in this case, unfortunately, isn't uncommon. It's been known to happen. It's not right, certainly isn't nice. It cost my client $300,000 more than the purchase price, not to mention its legal expenses. It's a real estate transaction, and in real estate, ordinarily, your word is your bond, and your reputation still counts for something. I think that the plaintiff asking for its fees when it did what it did here is, to use the vernacular, chutzpah. To award attorney's fees here against my client would be adding insult to injury. Thank you.
Thank you very much.
Your Honors, very briefly, I mean, I believe to get into the merits of the underlying action, it's clear in the record that action was dismissed on the merits. The allegations were found to have no merit, not to be actionable. So I believe that it's not an appropriate consideration for the court and completely irrelevant. With respect to the collateral issue, I again do believe that the prior case law cited by Your Honor establishes that an attorney's fees clause is in fact collateral. You could have a lot of other important clauses, choice of law, confidentiality, integration, deemed to be essential and extinguished in later litigation if the attorney's fees clause is deemed to be collateral. With that, I'll rest on my briefs.
Thank you very much.
Thank you.
The next case is People versus Hill.
Good afternoon. May it please the court. My name is Patrick Michael McGarrell. I represent Malik Hill in this particular case here. And if this case involved an eyewitness or a victim that came to court at trial, pointed to the defendant and said, that's the person who shot me, or that's the person that fired this gun in this crowd of people, if this case involved any sort of conclusive ballistic evidence or any other type of forensic evidence that would have corroborated the people's claims, and if this case involved a grainy black and white video, fuzzy from the 1980s or the 1990s, I would not be here today, but that's not what this case involves. What this case involves...
So you're saying there was no smoke coming from the gun?
I'm saying that it was questionable...
I've never seen a smoking gun except in the movies, but I'm asking you...
There's a reason for that, and that's because modern ammunition is manufactured with what they call smokeless powder, but aside from that, the smoke from the gun could be attributed, as I think there was testimony, to a number of factors, not the least of which is that the lighting conditions inside this bar, combined with people moving, lights changing, lights flashing, and the use of night vision technology, which completely alters the spectrum of light and completely renders colors more or less useless in the color spectrum, that could be attributed to any number of factors, but the people have never presented any evidence of that. What we have here, and I think we just...
You're saying that what appeared to be smoke coming from the gun was actually an artifact of the production of the video?
It could be. It absolutely could be. Now, when we look at the requirements of the Boyd case, this court decided, I think it was 4 years ago, that both the people and I have cited here, what are the requirements to get in this type of opinion evidence that, in my opinion, that's the defendant on the video there, which is now becoming more and more prevalent as we're in the 21st century with the advent, everyone now has video cameras all over the place here. But the requirements are, first, the witness must be sufficiently familiar with the defendant. Here we have testimony from detectives that said, well, I've basically seen this guy around the neighborhood. I know his family because me as a police officer broke his brother's nose.
Didn't testify, though, that he had seen defendant between 40 to 50 times and personally interacted with him about 4 or 5 times?
Right.
Isn't that a lot of interaction?
I would not say that seeing a person walking around is 40 to 50 times. And
You don't think that after you saw someone for 40 or 50 times and interacted with them for 5 times, you'd be able to recognize them?
To render an expert opinion that that is the person on this video, I don't think so.
Not an expert opinion, it's a factually based opinion. What makes it an expert opinion?
Well, what makes it an expert opinion is exactly what the people did, which is a perfect segue into my next point, which is we have the people presenting...
Also, didn't Detective Kaprowski testify that he had investigated a 2003 shooting relative to the defendant? He'd been to his home, he knew his family, he had spoken with his parole officer in times past.
That was after the fact. That was after the fact.
Parole officer, I correct myself.
Yes.
But this is standard lay opinion evidence, which is admissible, isn't it?
It's only admissible, according to this court, when there's a couple of things are met. Number one is sufficient familiarity, which I don't think has been met here, because especially when the detective goes, and remember, this case took 4 years, 11 months, and 2 weeks to indict. And in that almost 5-year time period, the detective first tells the district attorney that person on the video resembles Malik Hill, and then 2 years later he says, I'm sure it's Malik Hill. Now, what we have here is familiarity plus the video must be of marginal quality. Those are two requirements this court has said. It's not an either or, it's an and. And what we have is the people arguing at trial, and I think that the quote they used was, seeing is believing. You don't need the detectives to tell you that this is this defendant on the video. You can look for yourselves.
But counsel,
And they've said the same thing on appeal.
marginal quality is not a very objective standard. I mean, when I looked at the video, it was, you could see a bunch of people, you couldn't see their facial features clearly, but as I looked at it, I thought, well, if I knew any of those people, I could recognize them by the way they stand or something like that. But the quality of the video was such that you couldn't see their features clearly, you couldn't see, you know, whether or not what their hair was like or anything like that. You could just see them, it was not exactly clear. It wasn't fuzzy like you know, from a 1970s video, but it was still not something where you could see their features clearly. Why doesn't that meet the subjective standard?
That's not what the people have argued at trial, and that's not what they've argued in their brief here. They've said it here that it is so clear that it is not marginal quality. That's their position. If it's, and they cannot have it both ways, is what my point is. It's either marginal quality or it's not. There's no in between here.
Well, maybe they can. Did you argue, not maybe you yourself, but did the defendant argue below during trial that the video was of insufficient quality to permit in and of itself an identification of the defendant?
He did, and there was extensive complaints, and that's the other point I was going to make was this was properly preserved. There was an extensive colloquy at the start of trial about this, throughout the trial, during the trial, and defense counsel was complaining every step of the way that it was giving the people the opportunity to shore up an extremely weak case with opinion testimony from first and second grade detectives, which the people made a big deal about in their opening, during the testimony, and on their summation, about how great detectives they were and how they put their heart and soul into this case, and how basically the people were going to be allowed to say, without any other witnesses, without a number of the people from the bar, that as a first grade detective, in my opinion, that's the defendant, he did it, and it happened this way according to my non-existent ballistic expertise. And what we have here is a situation where there's another person with a gun clearly on the video that is pointing the gun in the same direction as the victim's buttocks, and we don't know, because the police decided not to retrieve the ballistic evidence, whether that gun could be, that bullet that struck the complainant or the bullet that struck the wall could be matched up to either one of those guns. Neither one of them were ever recovered.
Thank you very much. You'll have time for
Thank you.
rebuttal.
Good afternoon, and may it please the court. Jennifer Westfall for the people. I'll just start with this last point. I would like to say, first of all, that defendant's claims are at least partially unpreserved with regard to some of his later arguments about the opinion testimony that defendant possessed the gun, fired the gun, and that bullet struck Houston. Defendant also never raised any constitutional objections below. I would like to contend that knowing somebody or seeing somebody around a precinct, having interacted with them 40 or 50 times, and speaking to them 4 to 5 times is sufficient context to determine if you can recognize somebody from a video of less than perfect quality. And even the trial court below recognized that video was of less than perfect quality. I don't recall arguing that it was great quality video. I do recall arguing that it was somewhat higher quality. But you can see features if you know somebody or whatever looking at that video. I think it's enough to show that you could pick out somebody that you have sufficient contacts with.
Counselor, what about your friend's argument that essentially the people were trying to have it both ways, to show the video, and maybe the jury will find that the videos alone is enough to establish the identity of the defendant, and if not, well, the video is of marginal quality, and therefore we can, you jury can rely on the detective's interpretation of his view of what's on the video.
Whatever we made in our arguments, I believe the trial court's instructions gave the jury the proper way to view the video and the detective's testimony. They were reminded constantly that it was opinion testimony. They had the video for themselves, they had the arrest photographs, and they had seen defendant in court, albeit 6 years after the crime. I believe the jury was in the correct position to know the different quality and position of evidence in order to have come to the decision that defendant was a shooter. I don't think it's great quality video. I think it's of less than perfect quality, but I think it's good enough to see facial features, body type, the way somebody moves, and mannerisms, which is all a Boyd requires. Also, unless there are any other questions on that point, I would just like to point out defendant's guilt was proven beyond a reasonable doubt, and the jury's verdict fully comported with the weight of the evidence. The trial court also properly allowed the people to introduce limited testimony regarding defendant's flight from parole as evidence of his consciousness of guilt. And finally, his sentence is fair, appropriate, and should not be disturbed on appeal. Unless there are any questions, I rest on my brief. Thank you.
Thank you very much.
Thank you. I quote from the People's Brief on page 32 to 33. The jury could turn to ample segments of the video where defendant's facial features were sufficiently clear as to permit an identification and render an informed decision whether defendant was in fact the shooter. That's my point exactly. And where the rubber, I think, meets the road here is when we look at deliberations. We had an extended deliberation process here. We had an Allen charge. We had a deadlock note. We had requests for evidence, requests for the video, a question from the jury as to what is the defendant's height, and the court having to instruct the jury, there is no evidence on the record of the defendant's height. So this is obviously something the jury was struggling with and grappling with as they went through the extended deliberations. And what tips the scales here is the people highlighting first and second grade detectives, just as they did with parole, which was my second point, which I didn't get to, but mentioning the fact that the defendant was on parole 29 times in summation was entirely unnecessary. They could have proven this case without it and just simply said that the defendant absconded. He was picked up in Virginia, a short time later, and that could have been the end of it.
Thank you very much.
Thank you.
Russell versus New York University.
Good afternoon, and may it please the court. Bradford P. Mizell from the law firm McElroy, Deutsch, Mulvaney, and Carpenter on behalf of defendants, respondents, Joseph Temetz and Eve Meltzer. I would like to introduce John J. Pirano, Esquire of the Bar of the State of New Jersey, by the permission of the court, to participate in this appeal pro hoc vice on behalf of defendants, respondents, Joseph Temetz and Eve Meltzer.
Permission's granted.
I would like to end the...
I'm sorry, let me set the time again, because that wasn't the first, you weren't up yet. You don't go, you're not going first?
No.
Oh, no, okay, normally do it when you, okay.
The letter just said to do that as soon as the case was called.
During the calendar. Okay, it doesn't matter, it's fine. Let me just reset the time now. Okay.
Good afternoon, Your Honors. May it please the court. I'm Marshall Bellavin, Ballinstoll, PC, for the appellant, Dr. Susan Russell. In dismissing Dr. Russell's federal discrimination lawsuit, Judge Gregory Woods declined to exercise supplemental jurisdiction and specifically dismissed without prejudice the New York State and especially the New York City human rights law claims. It's clear in reading Justice Sherman's decision in the court below that there was not ample discussion, there was not ample view of the differences between the federal Title VII, ADEA.
Counsel, don't we have to look to decide whether or not there's any collateral estoppel effect? Don't we have to look at the actual factual determinations that were made to see whether they should be given any dispositive effect in this proceeding?
Yes.
So can you focus on that with respect to each of the claims? What factual determinations were or were not made that would allow these claims to survive? And could you start with the retaliation claim?
Your Honors, the factual determination made in the court below as to retaliation was made.
No, we really want to know the factual determinations that were or were not made in the federal court, because that would determine what collateral estoppel effect they get.
In the federal decision, the claim was decided essentially under the federal statute, and there was a determination, that there were not ample grounds for retaliation as to the federal statute. There was a determination of protected activity. There was a determination.
What about the statement, specifically in the Second Circuit, that said that Russell failed to raise an issue of fact as to whether NYU's justifications are mere pretext? Is that a factual finding or a legal finding?
Your Honor, it's a legal point if you're dealing with the standard that the court used to view that particular factual determination.
So, counsel, looking at that particular quotation, it begins, "We conclude that Russell has failed to carry her burden to create a genuine dispute of material fact, et cetera, as to whether there was an absence of retaliatory, as to whether it was retaliatory motive." So is there an indication in the Second Circuit decision as to how the definition of burden was being used? Was it burden pursuant to the federal statute or burden pursuant to the city or state statute?
It was a determination, again, it was a determination as to the federal statute. And the court specifically reserved.
Counsel, does that make a difference?
Well, if you view the facts that are in the state court complaint, there was a little over a 6-month time frame between the filing of the complaint in federal court and the termination of Dr. Russell by NYU. And the inference with that time frame, there's no hard and fast test, has to be 2 months, 3 months. The time period, okay, leads to an inference of retaliatory animus. And
I guess I'm not asking you that question. I guess I'm asking you, can the facts be construed differently according to which standard you use?
I'm sorry, Judge, I didn't hear.
Can the facts be construed differently? Can the result be different according to which standard you use, whether it's the standard enunciated by federal law as opposed to the standard enunciated by the state and particularly the city human rights law?
Particularly the city, yes, Judge. The construction of the city statute and the intent of the legislature, in terms of this particular statute, is that it be given liberal construction in terms of the time frame between protected activity and adverse employment action, for example. There's a broader construction for particular elements of any of the three claims that my client's bringing.
Sir, understand that before Federal Judge Woods was a motion for summary judgment, and the judge had the opportunity to search the record, and NYU defendants came forward and explained that your client was terminated, among other reasons, for misconduct in violating a protective order when Dr. Russell sent certain emails to a non-party witness in the federal litigation, correct?
Yes.
That was the basis, misconduct. And would you agree that in searching the record, Federal Judge Woods had the opportunity to review the grievance determination by the arbitrator that also agreed that your client engaged in misconduct during the course of the federal litigation, correct?
That was the finding, yes.
That was a finding. That is a finding of fact, correct?
Yes.
So right now we have a legitimate basis for termination, and then it would be your client's burden, factually, to establish that the NYU defendants termination in relying on that factual finding of misconduct engaged in some kind of pretextual basis or the underlying basis for the termination suggested a retaliatory animus. True?
That's true, and it could well be a jury question, Judge.
I understand. The question becomes is, when putting aside whether it's the liberal construction of the city HRL or the McDonnell-Douglas analysis in the federal level, would you agree that when the Second Circuit, in its 10-page decision affirming Judge Woods, when it said it concluded that your client didn't meet its burden factually establishing the animus, retaliatory animus, or in it being pretextual, that would be a factual finding, true?
Up to a point, Judge. It's factual according to the standards of the federal statute. And again, it's a separate inquiry that the trial court judge in the state court action has to provide and didn't provide. And that's, I think, the basis for, or one of the bases for our position that the collateral estoppel argument cannot hold.
Okay, thank you very, I'm sorry, do you want to ask a question?
Just briefly, while giving deference to the Second Circuit decision, wouldn't it be possible for a state court judge considering the reach of the city human rights law to find that plaintiff had prevailed in showing that there was a mixed motive without denying the appropriate weight to the Second Circuit finding?
Well, Your Honor, that wasn't done in the trial court in Bronx County. It simply wasn't done. The judge paid passing homage to the broad New York City administrative code and then proceeded not to analyze the city law separately. And if I may, Judge, in the state law complaint, the 9th cause of action at paragraph 168 cites the New York Administrative Code 8-107 sub 13. And it quotes it, and I think that the quote really is essential because one of NYU's chief arguments is that you can't impute the liability of quote, decision makers to NYU in this particular case. The quote is essential, I think. An employer shall be liable for an unlawful discriminatory practice and this is subsection B, upon the conduct of an employee, that's critical, employee or agent, which is in violation of subdivision 1 or 2 of this section, only where the employer knew of the employee's or agent's discriminatory conduct and this is an or, not an and, acquiesced in such conduct or failed to take immediate and appropriate corrective action.
Okay, thank you. Are there any other questions before we go on? Okay, let's hear from.
Thank you.
Good afternoon, Your Honors. May it please the court, Joseph O'Keefe with Proskauer Rose, LLP, for the defendants, respondents, New York University, Frederick Schwarzbach, and Robert Squilacci. The argument that plaintiff places before this court, in essence, suggests that facts are just in the eye of the beholder.
That's not
Reality
how,
here
I'm sorry, counsel,
is-
that's not how I read the brief. I'm not, it seems to me that when you're talking about, Second Circuit didn't say we find that such and such didn't happen. They said plaintiff didn't meet its burden of showing that something else happened, which is very different from making a factual finding. So I'm not sure why you are suggesting that that's utterly subjective. Burdens of proof are important considerations when you're making a finding of fact.
As a friendly amendment, why don't you add to that why you think the burden of proof, what impact it had on the federal action versus the state action in terms of a retaliation claim?
Well, with
Why
respect,
it was a factual issue that was being determined rather than just the application of the federal standard, which is different than the state standard.
thank you, Your Honor. The trial court here applied the factual findings and conclusions of the district court, which were affirmed by the Second Circuit. Specifically with respect to the retaliation claim, the court noted that the evidence that was offered by the claimants consisted solely of temporal proximity suggestion based upon a series of acts that occurred over time. The trial court determined that there was no basis for drawing an inference of discrimination based on temporal proximity because many of the acts that were cited by the plaintiff in the case had occurred many months, if not many years, before the alleged adverse employment action. The court similarly found that other than temporal proximity, the plaintiff in this case had offered absolutely nothing to support her suggestion that retaliatory animus played a role in the decision to terminate here, and that my client, NYU...
Wasn't there some comparison with a, wasn't some comparison made with a similarly situated male, to wit, Professor Thomas?
I don't recall that section of the district court decision, Your Honor. What I do recall is the court's conclusion that when faced with NYU's legitimate non-discriminatory reason for the actions that it took, namely the termination, the claimant had come forward with nothing other than this ill-founded temporal proximity argument, and therefore found that there was no retaliation, and that was affirmed by the Second Circuit.
So if we talk about the state action, didn't this professor, Professor Russell, the plaintiff, didn't she have a history of making complaints and filing grievances and an action ultimately with respect to the actions of Professor Thomas?
Yes, she did, and as the court concluded at the district court...
Which court, if you would?
I'm sorry.
Which court?
Thank you. As the district court, the federal district court concluded, my client did everything that it could in order to investigate each of those complaints by Dr. Russell. They conducted a complete and thorough investigation
and based upon her lack of complete cooperation, were unable to corroborate any of the allegations that she did make. At the point in time when Tometz made statements at a deposition that he had engaged in certain conduct, Tometz was no longer employed by my client and was not therefore subject to any sort of disciplinary action.
And you're saying that with respect to Professor Russell's actions, the investigation was equally as thorough. It ended up with her termination, and her conduct took place over the course of 3 days, as opposed to Professor, how do you say his name, Tometz?
Tometz.
Tometz, okay. His actions took place over the course of several months.
Well, my client made the determination that the misconduct that she engaged in, and namely that is improper communications with the professor that were in direct violation of a protective order of the district court, were sufficient to support the decision to terminate. That is materially different from the conduct engaged in by Tometz. And again, by the time my client became aware of the veracity of certain of Tometz's conduct, he was no longer employed, and therefore no action could be taken with respect to him. So it can't be really compared.
The period of time between the actions, the alleged actions of Professor Tometz and the deposition where he admits to some of the conduct, the wrongful conduct, is what? How many years?
It's I believe 3 years, but from the first time she was complaining about Tometz's conduct. However, I can't recall specifically how many subsequent complaints there may have been, and it would, of course, be a slightly narrower period than the 3 years.
Are you considering unimportant her complaint, her providing the information to NYU that the NYPD had confirmed that some of the communications to her came from an IP address located at Mr. Tometz's residence, Professor Tometz's residence?
No, with regard to that.
That was in 2013.
I'm sorry, I couldn't hear you.
That communication by her of NYPD's finding was in 2013, 3 years before his acknowledgement of responsibility.
There is significant evidence in the record, which was undertaken, a review of which was undertaken by the district court, and ultimately the district court made the factual conclusions that it made. Those factual conclusions were affirmed by the Second Circuit. I don't believe it's this court's role to revisit all of the underlying facts and testimony in the record which supported the ultimate factual conclusion of the district court.
The question, counsel, is which standard was used by the federal court. Did they take into account the city human rights law, which has a broader, more liberal interpretation and understanding of what civil rights, human rights law violations are? I mean, here you have pornographic material sent to her NYU mailbox, and you have unsolicited emails sent to her NYU email, and there's personal information disclosed in an NYU blog, and then you even have really offensive packages, shall we call them, sent to her NYU mailbox. It's such a concerning situation.
Well, again, Your Honor, my client thoroughly investigated that material, and based upon the limited cooperation of Dr. Russell, made the conclusions that it did. With respect to what the trial court considered, the Bronx County Trial Court, when it applied the standards here, on the face of the opinion, it is clear that it understood that the standard under New York City human rights law is broader than that under the federal law, but concluded, as did the courts in the cases we cited in the Second Department, that the ultimate factual conclusions of the federal court were dispositive. And The court acknowledged the breadth of the New York City human rights law. It explicitly engaged in both the McDonnell-Douglas analysis and the mixed motive analysis that's required by the city law, and it concluded that the factual determinations of the federal district court were nonetheless dispositive.
Any more questions? Okay, thank you very much.
Thank you.
Good afternoon, and may it please the court. My name is John Perano, P-E-I-R-A-N-O, and we are the counsel for the defendants Tomets and Mesler. I join in Mr. O'Keefe's comments with respect to the issues that have been already discussed. I'm going to make comments in two areas. Number one, the intentional infliction of emotional distress, which Your Honor just was starting to go. The plaintiff's initial brief here recognized that for an IEED, the conduct has to be so outrageous, so extreme in degree as to go beyond all possible bounds of decency and utterly intolerable in a civilized community. That's a very, very high bar. In 2016, the Court of Appeals in the Chanko versus American Broadcasting, the court said of all the IIED cases that it had considered, quote, every one has failed because the alleged conduct was not sufficiently outrageous. Here, I think the court has to take into consideration what today is tolerable in a civilized community. What's today is not tolerable in a community.
You're walking on a treacherous path, counsel. I don't know that we want to go into the details of what was allegedly delivered to her mailbox.
I'm not going to because it's in the record, Your Honor. But what I will say is I think you have to look at what the community standards are today, okay? 25 years ago, the language that you might use in front of children or the language that you might use in, quote, polite society is completely different than today. You can go out on the street today, Your Honor, and you see the children using the language that you wouldn't use 25. Look at the internet. Look at the emails. Look at even broadcast TV. 25 years ago, when Dick Van Dyke and Mary Tyler Moore had a very, very successful TV series.
Who?
You're very young, Your Honor. Every single bedroom scene was in single beds. You couldn't show them in a.
But counsel, we're talking. We're talking about more than language.
I understand, but okay, we know what we're talking about, Judge. What do you see on the internet today? What's available in the communities today? Pornography is available. All of these, and some of them, I am not suggesting for a moment, Your Honor, that some of the conduct here was not inappropriate.
I'm gonna take the bait. One of the allegations is that your client, Professor Tomets, sent vaginal lubricants to Professor Russell in her NYU mailbox and sent her pornographic materials to her NYU mailbox. And yet, I understand that there's been an extensive argument made as to the investigations that were made and the lack of cooperation. And yet, what we end up with is a termination of Professor Russell.
Your Honor, I'm not here to defend the conduct. I will say this, however. It was inappropriate. Some, frankly, was very childish, I think. some of it was crude. But I do not believe that collectively or individually, the conduct alleged meets the high standard of an intentional infliction of emotional distress. And I'll just point, Your Honor, to a recent case from this department, and that's the case of Barbados versus Grussine. There was a relentless campaign against the plaintiff in that case. There were false accusations of sexual relationship with a married individual, and there were all types of inappropriate and unwelcome approaches and requests to the plaintiff. The court said that conduct does not get over the bar that the courts have set in New York to sustain an IIED.
Thank you very much.
Thank you.
You have 1 minute.
Your Honor, if ever there was a case, however rare, for the reversal of the dismissal of an IIED claim, it's this one. And the complaint also alleges that the cardiac episode and hospitalization was a direct result of the relentless, over a period of time, campaign that undermined my client's sexuality, undermined her gender, and it was across the board. No, this is not a function of outdated standards where we're much more progressive and liberal in 2021. This is undermining at any time, at any period. Also,
Thank you very much. Thank you. The next case is Winkler versus Halmar.
Good afternoon, Your Honors. It's great to be here in person. Jonathan Schaub for the Halmar appellants. The Supreme Court's order in this case should be reversed because Mr. Winkler was Halmar's special employee. As a consequence, plaintiff's claims are categorically barred by the workers' compensation law's exclusive remedy provision. First, plaintiffs do not dispute that the Workers' Compensation Board in this case determined that Mr. Winkler was Halmar's special employee.
We have workers' comp records, sorry.
I'm sorry.
You didn't produce that decision in the record, right?
That was not a part of the record, no, Your
Right, so
Honor.
how are we supposed to consider it?
So, Your Honor, this is actually a part of the record now. We made this argument in our briefs.
No, you're putting it in your brief doesn't make it part of the record. It's a
But-
document that you're asking us to rely on a document that we haven't seen.
In this case, you
We're
don't
not
actually need to,
willing to do
rely on the document because plaintiff's counsel and plaintiffs did not deny any of these facts. They're concessions in this case. It's on the face of the briefs now that the Workers' Compensation Board has been admitted and conceded that.
So there's a very nuanced findings, though, as to whether or not an administrative agency's determination does or does not have collateral effect and is properly introduced. Without even having it before us, how could we possibly enter into that analysis?
Well, the first thing is that the court can take judicial notice of that workers'
But
compensation
how can we
finding.
take judicial notice when we don't have it?
We've provided the docket number for it is the first
So
thing.
we should go find it? We should leave the record and not rely on the record as an appellate court and go find a document outside of the record?
This court, and as recently as September of 2021, so a month ago in the Matthias decision, went and looked at the electronic filings that were available to look at what was produced below.
But to look at an electronic filing maintained by the court whose cases we review is very different from looking at records of an administrative agency that is not a judicial body.
But again, to go back,
Counsel,
the plaintiff's attorney has not denied that in this case. These are concessions. We're now circumventing the workers'
are there
compensation.
other things you can rely on besides the workers' comp decision?
Yes, there is. There's in fact the Costa versus Piermont decision from the Second Department. But to put one more point on this, and I apologize for belaboring
Counsel,
the court.
there's no evidence that your client paid the decedent's salary, right?
There is evidence in the workers' compensation. I'm sorry.
No. In the record, is there any evidence that your client paid the decedent's
Again, there's the
salary?
workers' compensation form that was filled out by.
Let's try my question again.
But
Is there any evidence in the record before us that your client paid the decedent's salary?
Yes, that's on record site 3290 of the record, and that's the workers' compensation form that was filled out by Precision.
Wow, counsel, you have to answer the questions directly. Are there any paychecks in here? Any payrolls in here that we've missed by some chance?
There are no payroll records in this record that show that. But again, this argument was made below, and plaintiffs did not deny that that our client, Halmar, was responsible for paying it. But just to jump back, this court...
Separate and apart from the judicial notice of the compensation board, isn't there a lot of evidence that negates the special employment, that they didn't have complete control over the work, they didn't employ the dispatcher who assigned the work on the day of the accident, it was not their truck that was used? Aren't these all factual elements that undercut special employment?
Well, I think the clearest evidence of this is that Precision, the general employer in this case, was dismissed by the Supreme Court on the grounds that it did not exercise supervision or authority or control over the work that was performed. That was the general employer. So if it wasn't the general employer exercising that supervision, authority, or control over the work, it must have been Halmar. And the testimony is...
Aren't there many factors that go into a special employment doctrine, not just that on the day of the work you told them to go do something? That by itself is not enough you have to completely displace.
And they were completely displaced because that's why Precision was let out of the case, because they had...
How could they be completely displaced when they're not even the ones who dispatched him to the work that day? Someone else could have come. How can they be the 100% employer when they don't even control where he went to work that day?
Because this is the Costa case from the Second Department where they said, as in this case, it was the general contractor who rented a pump truck and an operator, like was done in this case. In that case, as in this case, the evidence shows that the wages were paid by the general employer, or by the general contractor, excuse me. And in that case, as in this case, it was the general contractor who directed the pump operator where to place the cement in that case.
So we don't have any proof that the general contractor paid the wages. Precision supplied the truck, issued the safety gear, responded to safety concerns, and as my colleague indicated, also supplied the dispatcher who assigned the person to the work.
So pursuant to the rental agreement, Halmar did provide the truck. It rented the truck with the operator, which is again the Costa decision.
Precision provided the truck.
Halmar rented the truck from Precision and provided it to Mr. Winkler to use. And again, I don't want to belabor this point because I understand the court's feelings on this, but in the Martinez decision, this court said it is an arrogation of its jurisdiction to consider a tort claim when the workers' comp board has removed the right to sue by virtue of the benefits that were provided.
Thank you very much. You'll have time to rebuttal.
Good day, Your Honors. May it please the court, my name is Christopher Roberta with the firm of Ceruzzi and Spring on behalf of New York City and the New York City Department of Environmental Protection. All of the evidence I intend to rely on is squarely in the record. It's undisputed that the city had no property interest whatsoever in the location where the accident occurred. And when I say the city, I'm referring to both the city and the Department of Environmental Protection.
But you were the beneficial owner of Maybrook.
I'm sorry, Your Honor?
Hello? Sir?
I'm sorry?
I'm sorry. You were the beneficial owner. This was benefiting you. You wanted the mock-up because DEP was involved in the construction of an aqueduct.
That is correct, that the mock-up was
So there is case law that support that even if you are not the title owner of Maybrook, but you are the beneficial owner, that you would, in a sense, step in the shoes and be liable under Labor Law 200 and under the common law.
Well, I do believe those cases, Your Honor, they all cite two elements, a property interest and sufficient level of control, and that you contracted for the work for your benefit. There's no question that the mock-up was being done in connection with the city's aqueduct connection project. The issue here is both those two elements, the property interest and the issue of control.
But don't these cases clearly hold that you don't have to have a property interest to be deemed the owner, that that's not what the courts are going to look to in determining who is an owner necessarily?
Well, the highest authority cited in everyone's briefs was Scaparo v. Village of Ilion, a 2009 Court of Appeals that makes very clear that owners are not limited to a title holder, but encompasses person who has an interest in the property and who fulfilled the role of owner by contracting work for their benefit. And I note in that case, although the church had agreed to pay for the cost of materials, much like the city agreed to pay for the mock-up here, the court found that the church had no interest in the property over which the sewer lateral was
Isn't it
placed.
true that DEP asked Halmar, your client, to notify it in advance? Sorry, didn't DEP, your client, ask Halmar to notify DEP in advance of any work that it was going to do so that Hacks, the resident engineer, could inspect the site? Isn't that a measure of ownership?
I'm very happy you brought that up, Your Honor, because it's clear in the record that Halmar started building the mock-up at Maybrook without telling the DEP or the city. They didn't know it was being built at Maybrook. That is a perfect indica of a lack of control that results in them not being able to be found an owner despite the title, despite not having a property
So you're saying
interest.
that the fact that DEP didn't take advantage of that provision or request is dispositive here?
No, not that in and of itself is not dispositive, but the fact that Halmar started building the mock-up at the Maybrook site at the property site that's owned by Maybrook, that's owned by Halmar, that they didn't tell the DEP it was being built there. Halmar was responsible for the means and methods of building the mock-up. Halmar made the decision to change the bolts and the number of bolts that resulted in this accident. Halmar provided the safety plan for this job. Even if we're going to overlook the property interest, which I respectfully submit we shouldn't overlook the property interest, but even if we overlook the property interest, the city didn't have the requisite level of control to be considered an owner here.
Sir, did the city defendants have the right to insist that proper safety practices be followed?
No, Your Honor, the city did not control safety at Halmar's site. Halmar was in charge of safety on their site. It was Halmar's safety plan. That is in the record 4031 to 4032.
So
Robert
you're
Powers
saying
from
council.
Halmar.
I'm sorry.
So yes, no, the city did not have control. Their rules were not enforced in that zone. I know somebody made an argument that the city applied rules that were to apply inside the area where the mock-up was.
But the DEP rules were in effect in the Court North area where the mock-up was taking place. And the mock-up was being built precisely because this project, this proposal to connect the two aqueducts was considered dangerous, capable of falling apart or having problems, let's put it that way.
So
you're saying that the fact that DEP rules were in effect within the cordoned-off area, but not outside of it, that doesn't indicate control?
Yes, Your Honor, I would agree that speaks to control, and I can give a perfect analogy for that. For instance, the road, you drive down the street. The legislature creates the rules for the road. They make the motor vehicle laws. But the legislature is not out there controlling the streets and enforcing
Counsel, I don't
those
think
rules.
that's a good example. I don't think that's a good example.
No, I do think so, though. So because the DEP's rules, they made the rules, and they said, hey, you have to enforce these rules inside that cordon area. But the DEP themselves didn't enforce those rules.
Thank you
and
very
that's what
much.
speaks to control.
Thank you.
Thank you, Your Honor.
May it please the court, my name is Carl Lustig. I'm with the law firm of R.A. Lustig and Sassauer. I represent the plaintiff respondent. First of all, I'm going to deal with the city's involvement in the project. The designated area in Maybrook was cordoned off by barrels, by tape, and by gates. Testified.
What about the city's argument that it didn't have any interest in the property, and that's a required component under our case law?
Well, Your Honor, I would suggest to the court that the case of Kane versus Condoris is applicable, dispositive. The accident happened on a stairway on the way to the job site. What this court held was that became an implied easement. At the very least, the cordoned off area in this case was an implied easement, but it went further than that. Inside this cordoned off area, as this court noted, it was the city's rules that applied. There was no other work other than aqueduct project work that was allowed to take place within that cordoned off area. Everything outside of that area, that was non-project related work. Testified to by both Christopher Lovelet, who was the senior city employee who was in charge of the entire site, on site, and also by Robert Power, who was the senior Halmar person who was also on site. Both testifying that Maybrook was part and parcel of the overall project. Indeed, Mr. Lovelet, when he's characterizing the aqueduct project, talks about both Gardner and Maybrook. He makes no distinction. Maybrook was a construction site within the ambit under the contract and indeed defined in the contract as an on-site location. Consequently, there's no question whatsoever that the city was actively involved in this. And by the way, in order for a Halmar worker or any other worker to gain entrance to the cordoned off area, they had to sign in a sheet that was kept by the city of New York. The city had permanent employees on the job site in Maybrook at that location anytime work was done, and in order for anyone to gain entrance to do work, they had to sign their name. So the city had control over who was in there, and ultimately, in the contract itself, by laying out the specifications for the mock-up, they were in charge of everything that happened. The work
Sir,
that was
did the
done.
city have a right to insist that certain safety practices be followed?
Indeed, yes. As a matter of fact, the testimony in this case is that within this cordoned off area, it was a city's safety rules that applied.
Okay, so it's the city's safety rules. Who enforced them?
The city employees who were there on a day-to-day basis. That was among their many responsibilities, and it's unrefuted. Their many responsibilities in this case were to ensure that safety practices, the city's safety practices, were followed.
Mr. Lustig, you heard your adversary repeatedly turn to you and said you conceded that Halmar was a special employer. Can you speak to that?
Sure, I'd be glad to, Your Honor. I did not concede anything. What I did concede is that, yes, indeed, the Compensation Board did, in fact, determine that my client's husband, the decedent, was a special employee. But what they failed to point out is that, A, it was never raised to the lower court, that, in fact, in the Compensation Board, Halmar's attorneys argued that he was not a special employee in their appeal. They defaulted at the board level during the hearings. There were 3 hearings. They were unnoticeable 3. Halmar never had a representative, never had an attorney there, never called any witnesses. And then, after the decision came down, they filed an appeal. The appeal was denied by the Compensation Board, by the full panel, because the appeal was late. They blew the time to file the appeal. I indeed joined them, but the fact of the matter was, this is the finding of my client's decedent, as a special employee was purely procedural. And it was procedural by the fault of Halmar. The representations of what that finding was, that there were fact findings, is absolutely incorrect, and it is a complete...
Did your client have a right to participate, not your client, but Did your client have a right to participate in those proceedings?
I'm terribly sorry, Your Honor.
Did your client have a right to participate?
No, my client did not. I was allowed to appear effectively as an amicus. The compensation proceeding was between the compensation carrier for Precision, my client's real employer, the one that supplied the truck, and they brought the...
So what's your exact argument as to why it should not have collateral effect or preclusive effect, the finding of the board?
Because under the Court of Appeals case in Aki, there was no full, fair opportunity to litigate the issues. Indeed, there were no facts that were litigated before the Compensation Board. This was purely a procedural default by Halmar, which unfortunately resulted in my client being found to be a special employee by the Compensation Board. Is it entitled to collateral estoppel effect in the third-party action? The answer is clearly no. And in fact, Halmar at the lower court understood that. They did not raise that in their opposition to my motion for summary judgment. And indeed, while counsel may make all sorts of pronouncements as to what the record, transpired at the Compensation Board, they made no motion to enlarge the record, so this court would have that information before them.
Thank you very much.
Thank you.
Your Honors, may it please the court, Scott Winico for Respondent J Underground. Just briefly with regards, just to address the issue about judicial notice, they've never raised the Workers' Comp Board. They never asserted it as an affirmative defense. They never filed the motion to dismiss. They never even put any documents in the record. They cited some cases about judicial notice, allowing judicial notice to, of some administrative appeals that occur after an order has been filed. This Workers' Comp Board decision, to the extent it existed before this action was even filed, they never raised it. They don't have a right to assert judicial notice. If there's any other questions, I'll rely on the rest of my brief.
Thank you very much.
Good afternoon. May it please the court, Elaine Gangill from Vernon O'Neill for Hacks. In light of all of what's been stated here, I will rest on my brief unless there are any questions.
Thank you very much.
Mr. Lustig just made two important concessions. The first is he admitted that the Workers' Compensation Board determined that Halmar was the special employer in this case. The second concession you heard is that he admitted that he participated. Now, he characterized it as an amicus participation, but he admitted that he participated in the Workers' Compensation Board hearing. This is a total end run around the Workers' Compensation statute, and he should have known better than filing this complaint. He knew about the Workers' Compensation Board proceedings because he participated in it.
But sir, how do you address his
You went first, actually, so go ahead.
beauty and age before this?
Okay. No, I forgot.
I'll ask my.
Go ahead and ask your question.
So if that was so clear to you, why didn't you move to dismiss on that basis?
We were not involved in the briefing at that time. We did make an argument on the special employment issue for reasons that...
But you never moved to dismiss on the basis of that, and that would have gotten you out of the case completely.
Move to dismiss in what sense? After the motion for summary judgment, or
As
just...
part of the motion for summary judgment.
We were not involved in the litigation
When
at
you
that
say
point.
we, you don't mean your client, you mean
Our firm was not involved. I'm not sure as to what...
you can't, that doesn't excuse your client from making it.
But again, as the court held in Martinez, this is a jurisdictional issue. This
Okay, well, let me ask the question that I now remember, which is, what about the argument that there was no full and fair opportunity to be heard in that proceeding, which would preclude it from having any...
Mr. Lustig participated in the examinations of the witness. That is the quintessential example of a full and fair opportunity to be heard.
A related question. How do you distinguish the case, the Court of Appeals case that Mr. Lustig just cited, a key which, as far as my recollection from it, indicated that determinations of the Workers' Comp Board are not reflexively given or automatically given collateral estoppel effect in personal injury actions.
I would respond, I don't believe that was cited in his brief. I'm happy to submit additional briefing on that, but I would just note that Mr. Lustig has not denied that his client accepted the benefits. So whatever that preclusive effect may be of the determination, by virtue of the fact that the benefits were accepted from Halmar's comp carrier, they are precluded under the exclusive remedies provision from continuing this action against the Halmar defendants.
Thank you very much.
Three really quick points, Your Honors. First of all, with regard to the issue of control, specifically inside that cordoned off area at the Maybrook site, the lower court already found that the DEP had general supervisory control over the project, not actual supervisory control. That's in the record, page 24. Second point, all of the cases cited in the briefs about finding an owner, being an owner when he's not a title, those all found tribal issues of fact. They didn't find on the summary judgment stage that the non-title holder was an
Counsel,
owner.
My colleague made reference to the holding in Saragol versus New York Telephone, which is a 2004 First Department decision, which says the key in ascertaining whether a non-title holder party is an owner under the statute is the right to insist that proper safety practices were followed, not the actual exercise or non-exercise of control. So isn't that it? Isn't that it? DEP has safety rules. DEP, from what I'm hearing, had people on site to enforce those safety rules. People had to sign in. People had to sign out.
Signing in and signing out, Your Honor, I would say...
forget about, DEP had safety rules that had to be followed in this cordoned off area.
Handing somebody a paper to sign in, that's more of a ministerial
You're not
act.
hearing
I
what
wouldn't
I'm
say
saying
that
to you.
rises to the level of control.
You're not hearing what I'm saying to you. DEP's rules, the safety rules, are different from the rules. Where is this location?
Maybrook is a property owned by Halmar about 14 miles away from the property owned by DEP.
Okay, what county is it in?
I believe it's in Ulster County, but I don't remember
Ulster is
correctly,
kind of
Your
far
Honor.
away from New York City, but the DEP rules were enforced at this site.
They did not enforce those rules. Halmar enforced the DEP rules inside that cordoned off area, Your Honor. And lastly, the only other thing I'd like to add is that with regard to the special employee issue, regardless of how the court decides on that, I would just like to note that our clients have contract-based claims against Halmar that would survive any determination regarding special employee. Thank you.
Thank you. The next and last case is People versus Cromer.
Good afternoon, Your Honors. Matthew Craig from the firm Kaplan, Hecker & Fink, in association with the Office of the Appellate Defender, representing Dwight Cromer. There were real problems of identification in this case, and I'd like to focus my argument on two errors that allowed in improper identification evidence in support of the prosecution's new green jacket theory at trial. I'd like to begin with the Trowbridge error. The Trowbridge issue relates to the testimony of Detective Santiago, who was permitted, over objection, to testify about a photo array that Gonzalez had viewed, and then to imply that Gonzalez had in fact identified Mr. Cromer through that procedure. That testimony was allowed in because the door was supposedly open to it, but that reasoning has two flaws to it. First, it was the prosecutor who exploited any misimpression that the jury might have had about the written statement that Gonzalez had prepared. And second, implying the actual results of the photo array procedure violated the rule of Trowbridge. The door opening doctrine is really a doctrine of fairness in which one side may be permitted to introduce otherwise impermissible evidence if necessary to correct a misimpression created by the other side. But here, if there was any misimpression on the part of the jury, it was the prosecutor who caused it and exploited it. And if I may, I can walk through exactly what the prosecution did. Excuse me. The prosecution gratuitously had Gonzalez read his entire statement to the jury, He then proceeded to ask repeated questions about the March 25th lineup referred to in that written statement, even though he knew that the lineup that Gonzalez had viewed took place on March 28th.
But didn't that follow on Gonzalez having testified that he participated in a lineup as opposed into a photo array as opposed to a line? There was a distinction in his testimony between a photo lineup and a photo array and a lineup, and that's what the prosecution was trying to correct, correct?
No, Your Honor. The photo array, or the confusion came in for the first time when the prosecutor asked Gonzalez to read the entire statement on redirect to the jury. He then proceeded to ask questions premised on the flawed assumption that the reference to the lineup there was the same lineup that took place on March 28th.
But that was because there had been testimony about the lineup, which in fact had never occurred, and the prosecution was trying to clear that up.
There
wouldn't
was
look as if they were failing to introduce the results of another lineup.
Your Honor, there was no prior testimony that was incorrect about a lineup on March 25th. That came in for the first time on Gonzalez's redirect, led by the prosecutor. And it was the prosecutor who then, when he moved to have Santiago be permitted to testify about the photo array, who pointed to the fact that Gonzalez had read his full statement to the jury. That was done at the behest of the prosecutor, not by defense counsel. Regardless of whether there were any confusion, Your Honor, I'd just like to point out that it was further error to allow Detective Santiago to imply the results of the photo array procedure. The rule of Trowbridge prohibits a trial witness from testifying to the out-of-court identification made by another, and that's exactly what happened here. And the prosecution's only response to this point is to say that Detective Santiago's testimony was permissible because he didn't explicitly say that Gonzalez had identified Mr. Cromer, but rather implied it. But that's a distinction that makes no difference under the law. We cite various cases in our brief that go to that point. And if you just look at what Detective Santiago said here, I think it's clear that the jury would leave with the understanding that there was an identification made. Santiago testified that he put Mr. Cromer's picture in the photo array, that he showed that photo array to Gonzalez, that Gonzalez recognized someone, and then after that procedure, that Santiago proceeded to put an I-card out for Mr. Cromer's arrest. He then explained to the jury exactly what an I-card was and said it was the procedure for when someone is wanted for commission of a crime. If there's no further questions about that, just a brief note on a second error relating to the identification evidence, which is the unduly suggestive lineup procedure. The principal issue here is that the 4 fillers in the lineup were given identical short sleeve shirts to wear, and their bare arms were exposed in the photograph, whereas Mr. Cromer was put in the procedure with long sleeves. The uniformity of the fillers is what drew a clear line between the fillers and the suspect, in this case Mr. Cromer, and is the exact sort of visual clue that singles out a suspect improperly.
Sir, didn't each of the gentlemen, regardless of the length of the sleeves on the shirt, have a black-colored shirt on?
Yes.
And wasn't there like a colorful, maybe it was a child's bedding covering most of their, or at least part of their upper bodies and their waists?
There was a blanket placed over the laps of the 5 participants in the lineup, but it's conceded and not disputed that part of the bare arms of the 4 fillers was still visible. And I would suggest that the fact that the prosecution, the detectives in this case, knew to cover those arms but failed to do so illustrates that everyone knew that just having 4 people with their arms visible, otherwise identically dressed to one another, would cause a distinction, an improper one, with respect to the defendant.
Because I thought, to me, when I looked at the photo, the blanketing, the sheet, whatever that was, sort of took my attention away from the arms after looking at the faces, because it was not just a bland, uniform-colored piece of cloth. So, I don't know, the degree to which, and the arm was only, I think, partially visible. It wasn't like his whole arms were exposed. I think his arms were at least partially under that cloth.
Well, to be clear on it, it's the filler's arms who are visible, and all 4 of them, they clearly are. There was testimony at the hearing in this case that the photograph that shows the four sets of visible arms resembled what the participant in the photo array, or the lineup procedure had witnessed. And I don't think there's any dispute that this was a distinction between the fillers and Mr. Cromer in this case. And if I will, just a brief point on sentencing before my time concludes. I think our brief sets forth multiple grounds for reversal in this case, in addition to these identification errors. But it's also a case, if we get past that, that's well deserving of a sentence reduction. And
I'm going to let you address that on your rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the Court. Samuel Goldfein on behalf of the people. I'll address counsel-specific complaints, but just two overarching things about these arguments. One is that they're all unpreserved. He made no Trowbridge claim below. He didn't complain about the lineup below either. The second is that defendant's identity as present at the scene of this altercation was indisputable below. You have surveillance video placing him there. You have two eyewitnesses who place him there, and the defense witness, Fabian Torres, admits that defendant was there. So his identity is not in dispute, regardless of what happens with the evidence. As far as the opening the door and the lineup, defense counsel admitted a statement into evidence. The statement contained an error. It was a subtle error, admittedly. It was a mistake in the date, but it was a substantial error. When you examined it, it really suggested that there was the possibility of a second lineup. Regardless of what questions were asked about that statement, the statement was in evidence in its entirety for the jury to inspect, and if they examined it and found the error with the date, they would have been left to speculate. I think it's obvious that the statement caused confusion. It confused Gonzalez, it confused the prosecutor, it confused defense attorney. Nobody recognized that there was a mistake in this date, and as soon as the prosecutor did realize it after the adjournment, he brought it to the court's attention and it needed to be corrected. As far as the inferential bolstering goes, I think in any case, in all cases, really, the jury, there's like a legal fiction that has to be developed. The jury is going to be told that a witness had an interaction with a police officer. They're not going to be told what the contents of that conversation was. And then afterwards, the police officer puts out an I-card for the defendant's arrest. That's baked into the system. The fact that we had to mention that as part of the conversation, he viewed a photo array, not a corporeal lineup, that was a result of the confusion caused by the defense exhibit, regardless of the people's questions. As Your Honors pointed out with the lineup, I think the lineup was not unduly suggestive. The filler's arms were covered with a blanket. Their t-shirt sleeves are long and baggy. They go down to the elbow. The blanket, they're holding the placards underneath the blanket, further raising them up above their bodies. I don't think they're in the lineup photos in like their full ready position, but even the way that they're sitting relaxed, their arms are hardly visible and clearly not a part of why Gonzalez identified this defendant. He had ample opportunity to view him, both during the initial, when defendant comes up and starts trying to harass him, then when he's fighting him, chasing him, during the shooting itself. So at all points, Gonzalez had the ability to identify a defendant. And again, even without Gonzalez's testimony, there's ample evidence that the defendant was the shooter. The gun's found in his house, underneath his jacket. We know it's his jacket because we see it in the video. His name is in the receipts in the pocket with the date of the incident. There was just no doubt here. So unless there are any other questions, I rest on my brief and ask that you affirm. Thank you very much.
What about, because I think it's going to get brought up on rebuttal of the excessive sentence claim.
Yes, Your Honor. I believe that the sentence here is fair and appropriate given the egregiousness of defendant's conduct. I mean, he's carrying a gun with him, and he sets out looking for trouble. I mean, we can see it on this record. Him and his friends, they start harassing a man outside the bodega for no reason. They throw his stuff into the street. Then they pick a fight with Suarez and Gonzalez for no discernible reason. They escalate a verbal dispute into a fist fight, and then they chase down and shoot these men. Defendant actually, it's a product of cold calculation. It's not a heated debate or an argument. He points the gun at Gonzalez's head and then stops and reconsiders and lowers it and lets them go. Then he changes his mind again and he goes and chases after Suarez and shoots at him 5 or 6 times. I mean, this is egregious, blatant conduct. He went out there to murder somebody for the fun of it, and he tried to do it. So I think his sentence is fair and appropriate. I also, in anticipation of the argument that he received multiple sentences for possessing the gun 3 days apart, as an effectively, he didn't receive any time for possessing the gun at the time of the shooting. That sentence was concurrent with his longer attempted murder sentence. So he's really only effectively being punished for possessing it 4 days later. But regardless, consecutive sentences would be applicable in this case.
Thank you very much.
Thank you, Your Honors.
I'll speak just briefly to 2 of the points made about the identification issues and then move on to sentencing. On the preservation point, I think we set it out in our brief on both the Trowbridge issue and the lineup issue. There was discussion of all the points we raised in our brief. Trowbridge was discussed multiple times, and even the prosecutor's role in sort of creating the confusion was recognized by the judge, who said that you knew what you were asking about the whole time because you had the written statement all along. Second, you heard my friend on the other side say that there was no dispute about identification in this case. There clearly was a dispute. The only person who saw the shooting was Suarez himself. Suarez twice told detectives that someone else who was captured on the surveillance video had shot him and didn't even make an identification until trial. There's other errors that we discussed in our brief. And lastly, about sentencing, I do think we discussed various cases involving similar, even more egregious crimes that involved lower sentences, and we think that the principle of proportionality applies. And I think it's notable that the prosecution here offered 9 years, knowing full well all the conduct involved in this case and Mr. Cromer's criminal history. Lastly, there's a number of mitigating factors, including a history of substance abuse, emotional abuse, and physical abuse at the hands of his parents, a history of counseling. All these things are what the case law directs this court to consider on this review. They're ignored in the prosecution's brief, and we think contribute to the cause for a sentence reduction here.
Thank you very much.
Thank you, Your Honors.